Open this hearing of the Senate Foreign Affairs, Defence and Trade References Committee into Australia's sanctions regime. The committee will be conducting today's hearing via video conference. I'm Senator Chandler, the chair of the committee, and I'm joined by Senator Ciccone and Senator Birmingham. These are public proceedings being video streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. I remind committee members and witnesses who are appearing via video conference and who are not speaking to mute their microphones. I now welcome Dr. Anton Mosienko and the following representatives from the ANU Law Reform and Social Justice Research Hub: Mr. Max Thomas, Mr. Fabian Bonacci, Ms. Esther Bornstein and Ms. Bridie Liu. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today? And we might start with the witnesses who are in the committee room.
My name is Max Thomas. I'm a student researcher at the Australian National University Law Reform and Social Justice Research Hub.
My name is Fabian Bonacci. I'm also a student researcher at the ANU Law Reform Social Justice Research Hub.
My name is Bridie Liu and I'm also a student researcher for the ANU Law Reform and Social Justice Research Hub.
My name is Esther Bornstein and I'm also a student researcher at the ANU Law Reform and Social Justice Hub.
And Dr. Mosienko?
Thank you. I'm Anton Mosienko, Senior Lecturer in Law at ANU, appearing in a personal capacity.
Thank you. I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions, and we might again start with the representatives from the ANU Law Reform and Social Justice Research Hub.
Good morning, Chair and members of the committee. The ANU Law Reform and Social Justice Research Hub welcomes the opportunity to contribute to these important discussions about Australia's sanctions regime. Australia's implementation of Magnitsky-style sanctions since 2021 was a significant step forward in our ability to target human rights abusers and corrupt actors. However, we submit that the current application of these sanctions has been limited in scope and inconsistent in practice. Our submission deals with what we view as three key issues. The first is misalignment with allies. The approach so far of the Department of Foreign Affairs and Trade has been selective alignment with overseas countries with respect to which individuals to subject to sanctions. For example, Asa Zarapur, who was the Iranian Minister for Communications until a few weeks ago, pioneered nationwide shutdowns of Iran's communications network to suppress, track and punish protests. He is but one example of an individual sanctioned by the European Union, the United States and the UK who has remained missing from our list, nor has Australia sanctioned Russian individuals involved in the forced deportation of Ukrainians, including children. We'd note that the United Kingdom and the United States have done so. They've added them to their sanctions list. Despite this being a fairly non-contentious designation listing, we would suggest that this selective alignment with overseas allies suggests that there might be administrative concerns or problems coordinating our sanctions with allies, which allows individuals to fall through the cracks. And recommendation 7 of our report deals with how this coordination might be more effective. Our second criticism currently of how the Magnitsky Amendment is being applied is with respect to the underutilisation of the amendment. And we would suggest that Australia should take a more uniform and proactive approach to applying the Magnitsky sanctions legislation. We would suggest that the department currently views Magnitsky sanctions more as a tool of just foreign policy. They very rarely consult human rights or corruption experts, which was the actual point of introducing the amendment in 2021. And the joint report to the committee made that so much clear. And I think the submissions of Geoffrey Robertson to this inquiry view the stark disconnect from what the purpose of introducing this amendment was in 2021 and how it's not really being carried out in an effective way to target human rights abuses currently. We submit that despite the Magnitsky legislation having a very wide scope, the actual number of sanctions which has been applied is starkly low. We would note that Australia has listed 73 individuals since 2021, and we would contrast that with the 238 the United States have listed pursuant to their global Magnitsky law. And so we would suggest on that basis there are many notable gaps. For instance, Australia has not imposed any Magnitsky-style sanctions on China with respect to its treatment of Uyghur Muslims, or for Israel, or on Israel for actions in Gaza determined to be human rights violations by the International Criminal Court. We would suggest that taking a more proactive approach would avoid the perception that sanctions are politically motivated. Having clear designation criteria would reduce the diplomatic fallout, allowing Australia to expand its use of thematic sanctions such as those targeting corruption or human rights violations. Our third suggestion is, once we've decided to list a country onto our designated sanctions list, we should try and optimise for the efficiency of these sanctions. Firstly, by introducing an early reporting mechanism for Australian businesses, and secondly, we would advocate for a mechanism of distributing the proceeds of these frozen assets to the people that many of these corrupt human rights abusers sought to harm. We once again thank the committee for the opportunity to contribute to the inquiry and appear today. We hope that our submissions might be helpful in informing these important policy discussions.
Thank you very much. Dr. Motsienko, an opening statement from you, please.
Thank you very much. The topic that we're discussing today could hardly be more important given the developments of the past couple of years. Australia now has several thousand individuals and companies listed on its consolidated sanctions list, which means that their assets in Australia are supposed to be frozen and no one in Australia is allowed to do business with them. And Australia is also, in line with its overseas partners, using trade sanctions to prohibit the import of certain sanctioned goods into the country, but also prohibit the exportation of certain items to sanctioned countries. The question of how those rules operate in practice is therefore very timely, given the significant impact of those restrictions on sanctioned individuals, but also Australian businesses writ large, who need to know what they can and cannot do to remain compliant with sanctions. There are two broad issues that I would like to highlight in these opening remarks. The first one relates to sanctions policy. I would echo the point about selective alignment with certain overseas designations. Even though the number of entities and individuals listed by Australia conveys the impression of an active and expanding sanctions regime, the vast majority of those have been sanctioned by overseas jurisdictions first, especially the United States, the EU, and the UK. Now, what that means is that Australian designations come considerably later. That means sometimes months and occasionally years after the designations elsewhere, which of course gives sanctioned individuals the opportunity to remove their assets from the jurisdiction in anticipation of sanctions being imposed. The other key aspect to this is that Australian sanctions are likely to be most effective if they are addressed at individuals and companies with assets or other interests in Australia. And so one would expect those alleged perpetrators of whatever misconduct is being sanctioned to be prioritised for sanctions and for Australia to go first and foremost after targets with a significant nexus to Australia. From looking at the current designations list, it is unclear to what extent that process is happening and to what extent Australia does have the capacity to identify sanctions targets with significant links to this country. And this leads on to the second important and related question, which is sanctions enforcement. We need to realize that the mere promulgation of sanctions is in effect a press release by a government when the government says you cannot deal with persons X, Y, and Z. And then the hard work of enforcement begins, and that entails identifying the property that they might have in Australia and ensuring that businesses in Australia don't interact with sanctioned persons. Therefore, the capacity to do that is absolutely crucial to the effectiveness of the Australian sanctions regime. And we have not seen many enforcement actions so far. The two enforcement actions that I'm aware of are historical and pertain to sanctions imposed against Iran and North Korea some years ago, nothing related to the more recent Russia sanctions. And there is a constant uncertainty as to, for example, the amount of assets frozen under recent Russia-related sanctions. There is also a crucial point of resourcing that needs to be explored. For example, how many people work on sanctions evasion investigations in the Australian Sanctions Office and the Australian Federal Police, and what is the actual capacity to ensure that Australian sanctions do not stay, as I said, as a press release, but are in fact enforced effectively in this country. So those are the two broad topics that I would highlight at the start of this hearing. And there are many more aspects to both the sanctions policy question and the sanctions enforcement question that I think we can explore. But I will pause here and I will be guided as to what you senators would like to focus on.
Thank you very much, Dr. Mosienko. I'm just checking if Senator Birmingham is there and available to take the call.
I am Senator Chandler. Thank you very much.
Thank you.
Currently in a car, so apologies, I won't turn the camera on right now until I get to my office from the airport very soon. But appreciate very much your opening statements and all of you for the submissions that you've made. I might start with a couple of general questions that appreciate both groups of witnesses responding to, and then there are also a few additional specific ones that it would be good to cover. But can I just ask broadly, how can you each elaborate on how it is that Australia might better coordinate on both the scope and the timeliness of the application of sanctions in concert with our partners and allies? And in looking at that, both scope and timeliness factors, also touch on how you think we can most effectively do so without compromising Australia's own sovereignty and responsibility for making these decisions ourselves.
I'm happy to start on that. I suspect there are two aspects to that that need to be addressed. So in relation to the timeliness of sanctions designations so far, there is a general question in my mind as to A, how Australia decides which foreign sanctions to align itself with, and B, what are the processes that are then put in place within DFAT and the Australian Sanctions Office to give effect to those sanctions. So, for example, if we have a batch of designations relating to Iranian targets or Russian targets or whatever other sanctions regime we're talking about, why is it that some people are sanctioned by Australia and some people are not? And why is it that from those people who are not originally sanctioned, some do end up on the Australian sanctions list, but years later? What are the processes at play there? I think that without delving into those details of processes happening in relevant Australian government agencies, it's difficult to say what exactly needs to be changed. But I think that's one aspect to this question. The other important aspect to the question of multilateralism, though, is that Australia is likely to be in a distinct position from effectively any other sanctioning power, be that the US, the UK, the EU, because a number of people who would have assets or interests in those places would not necessarily have any particular interest in Australia. And the other way around. One could imagine, for example, that there would be a number of people from, let's say, Asia Pacific who could be sanctioned by Australia, for example, in connection with so-called Magnitsky sanctions, corruption and human rights abuse sanctions, or indeed other sanctions programs. And so there, Australia is the natural country to lead the effort. One can't rely on the US, the UK, and others to do those designations first. And that poses a different question of how Australia makes those designations as the first mover and then brings other allies along and convinces them to follow Australian sanctions designations, which is the opposite of what we've seen so far. But I think it's also an important aspect of developing an independent sanctions policy, while B, preserving that multilateral approach that ensures the effectiveness of sanctions. And the one example of good practice in this domain that I would point to and that I've commented on in my submission is the recent use of cybercrime-related sanctions by Australia, where several Russian individuals accused of cybercrime affecting Australian interests, including the hacking of Medibank, were designated in concert by Australia, the US, and the UK, the implication being that no one in those countries is allowed to pay any more ransom payments to those people when they encrypt the files of the victims. And this is an example of a designation that directly responds to a threat to Australian interests, but also has been successfully multilateralized with allies. And I would hope that we would see more of that moving beyond the domain of cybercrime across a variety of Australian sanctions programs.
The thing I'd add with respect to international coordination with our allies is that Australia is presently excluded from a number of the coordination mechanisms for international sanctions, whether it be the G7 enforcement coordination mechanism meeting and also the European Union Sanctions Coordinators Forum. Australia does participate as a country that observes as often friends of these organisations, but the problem that comes from having sort of a hodgepodge of coordination mechanisms is that we often just rely on, the United States Sanctions Office picking up the phone to the department and saying, well, it's time to sanction this individual. We would instead be in favour, perhaps, of having a more organised, formal coordination mechanism with our allies to prevent what seems to be a huge delay in implementing many of these sanctions. The thing that I would add specifically about Magnitsky sanctions is that we would suggest that there should be clearer criteria by which our allies and Australia implements these sanctions. And so, the United Kingdom, the US, the EU and Australia were purportedly, champions of the rule of law, but we're so inconsistently applying these for presumably diplomatic reasons. That's probably a reason why, the Australian government hasn't significantly sanctioned the Chinese government with respect to its treatment of the Uyghur Muslims in Xinjiang. There's probably political reasons why we haven't sanctioned Israel to a very large extent, and I think the submissions that have been made by other people to this inquiry make that clear. The thing that would resolve this international coordination problem would be to have a clearer set of principles guiding when corruption and human rights sanctions should be implemented. So it operates as more of a trigger which prevents sort of the diplomatic fallout which might come, or the political backlash from having inconsistently applied many of the Magnitsky sanctions to countries who obviously do have human rights abuses but aren't being targeted under our sanctions program for that. And so our submission is that there should be clearer criteria by which the Australian government implements Magnitsky sanctions, and we should coordinate that criteria with like-minded allies.
Senator Birmingham, if you're asking any more questions, you might be on mute.
Yes, sorry, Claire.
All good.
That's okay. Sorry, I was thanking you, and it's particularly useful to highlight some of those coordination mechanisms and the opportunity for Australia to seek to be engaged in those, especially at least as it relates to enforcement pathways. Can I ask, do you think it is possible for Australia to operate without compromising sovereignty or other factors, but with a degree of confidence in providing some mutual recognition of analysis and decisions taken by partner nations such as the UK or US, Canada or EU, rather than clearly the time and resources that are applied within DFAT to potentially duplicate much of the analysis that others will have already undertaken?
Well, I'd say that the two are certainly not mutually exclusive. It's certainly possible to coordinate with our allies while at the same time maintaining a degree of sovereignty. And at that point, I'd echo what Dr. Moisenko has said about the Asia-Pacific region, because obviously Australia is the major Western power in the Asia-Pacific. And as we highlighted in our submission, there is the risk that we become a haven for the assets of abusers. So there is the need first and foremost to coordinate and certainly to use that work done by our allies like the UK and the US to prevent Australia becoming that haven due to gaps in our sanctions regime. However, especially regarding Magnitsky sanctions, I'd echo what Max Thomas just said regarding the need to essentially be less diplomatic and be more willing to be proactive in applying the Magnitsky sanctions, especially towards, violent Israeli settlers. Even though we have implemented a fairly small number of Magnitsky sanctions regarding this, the majority of reports indicate that the scope could be much wider and probably should in comparison to the legislation that Australia has implemented to allow for Magnitsky sanctions. So essentially, we would put forward that it's definitely possible to coordinate efficiently and more efficiently with our allies, but we do need to essentially prioritise becoming more sovereign in our regime and potentially taking the lead on some sanctions regimes to the point where our allies could follow suit, so to speak.
There are just a couple of points I would add to this. So Australia is a member of the REPO task force, the Russian elites, proxies and oligarchs task force that was set up internationally to deal with Russia-related sanctions, specifically after the full-scale invasion of Ukraine. I think there is an important question to consider as to the lessons of that coordination and whether they can be extended to other sanctions programs as well, moving beyond Russia sanctions. So is there something to be said in favor of perhaps expanding the approach of the REPO task force? But all of that is contingent on the learnings to be drawn from its actual operation. The other aspect to this that I would highlight, which perhaps might go somewhat against the gist of your question, but I think it is important to highlight, is that there are also some dangers in relying on allied designations to the extent that once sanctions policy becomes equivalent to simply copying and pasting what other countries have done in the sanction space. And of course, I'm not suggesting for a moment that that is what you're calling for. I think it's just something that has the tendency to happen. We've seen that in other countries as well. Very often the US is the first mover, and then other nations around the world effectively copy US designations and move ahead. What I think is missing there is precisely that point about identifying sanctions targets with the greatest connections to Australia and ensuring that the Australian sanctions policy is coordinated, but is also to some extent tailored to the specific circumstances of Australia and the targets that are going to be most affected by Australian sanctions. So I think it's a two-pronged effort. On the one hand, yes, more effective coordination and not duplicating the work by others, but then on the other hand, creating an expectation that there is, in fact, a degree of independent work done within Australia to identify how the Australian sanctions policy can be best advanced.
Thank you both. Appreciate that. When you've each touched just on consequences issues, so can I ask for some responses around how we manage the consequences of sanctions better, particularly at what point we should consider moving from freezing to seizing of assets, and what the barriers you see to that are, and how Australia could best do so.
So this is a hugely important topic that is part and parcel of this broad question of enforcement, but also has specificities to it. So when we talk about the freeze to seize debate, it's also worth focusing on the freeze part of it and just ensuring that Australia has the right resources in place and the right capacity to freeze the assets that are subject to sanctions. And what I have in mind in particular is that when we talk about individuals or companies with significant amounts of assets, and if they know that they're likely to be sanctioned because they're involved in misconduct, then they're unlikely to hold those assets directly. They will use proxy owners, nominees, and so on. And there's a genuine question around the capacity and the processes in place to identify those indirect holdings. So the question of identifying frozen assets is a hugely significant one, and I think that it's really been brought home by the experience of Russia-related sanctions, where so many companies and individuals were sanctioned that it's only natural to ask the question of, has everything been found? Has everything been identified in Australia? How much has been frozen? Is there more to freeze? But leaving that to one side and moving to the question of freeze to seize, it's often said that sanctions are temporary by nature, that they can't be used to confiscate sanctioned assets, but that's half true. That kind of misses the point to a great extent, because sanctions are temporary measures, but the real question is, are there other legal tools that are available in order to confiscate frozen assets? So let me give you an example. Let's say Australia freezes property that derives from proceeds of crime. It might be temporarily frozen under sanctions, but then, if it is proven to derive from proceeds of crime, it is liable to confiscation based on Australian proceeds of crime laws, and no legal reform is necessary for that. The only thing that is necessary is the effective identification of frozen assets and then the use of existing proceeds of crime authorities in order to confiscate that property. There is one particularly important side to this, which is the confiscation of property involved in sanctions evasion. Let's say we have property that has been frozen under Australian sanctions, and then someone seeks to remove it from the jurisdiction and thereby engages in sanctions evasion. My understanding of the current law is that it is possible to confiscate that property because it becomes proceeds of crime or instrumentalities of crime because it suddenly becomes involved in sanctions evasion. This is something that the United States has done in particular, including with the widely publicized case of a yacht belonging to a Russian oligarch that sailed from the United States, was liable to confiscation as involved in sanctions evasion, was then seized off the coast of Fiji and returned to the United States. Now, we haven't seen those kinds of enforcement actions so far in Australia, and I think it is an example of an area that is worth looking into. Are there investigations ongoing into sanctions evasion, and is there an understanding within law enforcement agencies, and is there an appetite to seize assets involved in sanctions evasion? Now, finally, the last component to this discussion of freeze to seize that I would highlight is the reason why the issue became so controversial and so acute, and that's specifically to do with state-owned Russian assets that have been frozen around the world to the tune of $300 billion after the full-scale invasion of Ukraine. What is difficult about that situation and what is important about it is that here we have property that directly belongs to a sovereign state. So in principle, it is protected by sovereign immunities, but it is also a sovereign state that owes Ukraine, the victim of its aggression, the obligation to pay reparations. And so the question arises whether countries can and should legislate domestically to transfer those frozen Russian assets to Ukraine in order to satisfy Russia's obligation to pay reparations. There have been ample discussions of this topic. There have been memorandums published on the subject by leading international lawyers, including members of the International Law Commission, leading academics who argue in favor of such a transfer. There are some dissenting views as well. The United States has legislated in order to authorize the president of the US to effect such a transfer of Russian state-owned property, but that hasn't been used so far. In Canada and the UK, legislative proposals are pending in respective parliaments and have been actively discussed. What is strikingly missing in the Australian public discourse is any view from the government as to what its position is in relation to this whole issue. And so if one compares the state of affairs in Australia, which is silence on this matter with the state of affairs in other comparable Five Eyes countries. There's much greater discussion there and much greater activity on that front. There are legislative proposals either adopted or pending, and I think it is an area where Australia would do well to step up and kind of engage with this question and clarify where it stands on the issue of asset repurposing, which is the sort of last key part of this freeze to seize debate.
Thank you. And can I just, on that, and where time will require Senator Ciccone having an opportunity for questions as well, but there have been reports, for example, of businessman Oleg Deripaska having an ownership stake of potentially 20% in Queensland-based alumina refinery via his company Rusal, and this is a sanctioned businessman. How plausible do we think it is that in fact, of those individuals that Australia has sanctioned, there are actually wealthy, globally mobile people who have significant assets in Australia, in addition to those questions around state-owned assets that have been raised?
I understand that from the approximately 10,000 entries on the Australian sanctions list, a proportion of them are duplicates, but it's still thousands of individuals and companies. Around 2,000 pertain to Russia-related sanctions, so Russian individuals and companies, including almost all or a significant proportion of the wealthiest people in Russia. We know that at least some of them have business interests in Australia. The case that you've referred to involving the Queensland alumina refinery is but one example of that. There has also been another court case with a Russian businessman, Alexander Abramov, challenging sanctions imposed against him by Australia unsuccessfully. So even that small sample of court cases demonstrates that there are a number of people from those sanctioned under the Russia program with interests in Australia. And that raises the question of how many more are there and what is the amount of assets frozen in Australia under the Russian sanctions program. I think it is a question for which we need a clear answer. And my understanding is that the information in the public domain here has been patchy. So, for example, we know that in the EU, as of a year and a half ago, $60 billion worth of quote-unquote oligarch property has been frozen. We know what the amount is for the United States. I can't recall it off the top of my head, but we know what it is. What is the amount for Australia in terms of both oligarch property and state-owned property? That is an important question that leads back to that all-important issue of sanctions enforcement. There is also a slightly more technical issue that I would still highlight in case that is of use to the committee, which arose from the Deripaska case, which is quite interesting, because in the Deripaska case, the federal court ruled that if you do business with a company that is minority owned by a sanctioned person, so in that case, Deripaska's shareholding was approximately 25%, and 12% belonged to another sanctioned Russian individual. Even if it's a minority shareholding, you still can't do business with that company because by providing goods to it or providing money to it, you're making resources available directly or indirectly to a sanctioned individual. And that can have interesting and difficult ramifications for a number of Australian companies who deal with businesses that might be owned to some extent by sanctioned individuals. And there is a question of what is that threshold when you can't do business with a company that's minority controlled by a sanctioned individual. I understand that question to be unresolved, and it's probably something that the business community is expecting some answers about from the Australian Sanctions Office.
Thank you.
Senator Birmingham, I am keen to move the call around a bit because I know Senator Ciccone has some questions. Would you be able to wrap it up soon?
I can, Senator Chandler, certainly. Look, I was just going to, off the back of that evidence, just refer to and seek a response which goes, I guess, to the resources and tools applied to identify assets that require freezing. Evidence given in a response to a question asked by Senator Patterson of the Australian Federal Police back in June of this year was that the AFP had undertaken some 1,800 plus searches on sanctioned Russian individuals, but, quote, the AFP did not identify any Australian-based assets as a result of these 1,800 plus searches. Now, none of us expect that there are huge Russian individual asset holdings across Australia, but given the scope and action of the oligarchs and others who have been sanctioned, it does seem implausible to think that there are no such assets, including the ones that have been subject to media speculation that I asked about before. So I guess just following on, my final question there is, what tools could be better applied to ensure that Australia is identifying such assets and isn't in a situation where sanctions are levelled, but in fact the sanctions don't ultimately have effect to the individuals and their assets that they may have hidden in Australia?
I think there is a dire need for clarity as to what Australian businesses need to be doing when they try to comply with Australian sanctions. That relates especially to the financial sector, banks, but also potentially other businesses. So if you're a bank and you just do a search of your customer base and you say, well, great, we don't have any accounts in the names of Vladimir Putin, Kim Jong-un, and others, therefore we've done our sanctions compliance, there's nothing to see here, and we move on. That is not a proper approach to sanctions compliance, and a more intelligence-led approach needs to be taken. One needs to actually try and identify companies that are more likely to be controlled by sanctioned individuals, and one needs to get an indication from the government, in this case I believe the Australian Sanctions Office, as to what the best practices are, but also what the regulatory requirements are. Because a de minimis approach to sanctions screening is simply not going to work. It is important that businesses do more than that, and the government tells them exactly how to do that and what to look for.
We would echo many of the sentiments just mentioned by Dr. Moisenko, especially regarding how the Australian Sanctions Office could provide more support on informing Australian companies and businesses on regulatory requirements. But we think it's also worthwhile to highlight some points from our submission regarding looking at the UK as an example of how we can better support sanctions compliance for Australian companies and businesses. We suggest looking at adopting legislation similar to the UK's legislative scheme, which currently mandates that organisations submit reports to the Office of Financial Sanctions Implementation if they're suspicious that their client may be a sanctioned individual or entity. This involves creating reporting obligations that apply to those specified in the statutory instrument for a certain sanctions regime, and these firms are then required to inform the office as soon as practicable if they know or reasonably suspect a person is a sanctioned individual or entity or has committed an offence under a sanctions regime. In fact, the UK government actually, in December 2023, in response to the Russia-Ukraine invasion, has mandated additional reporting requirements for relevant firms under the Russia Sanctions EU exit regulations that require UK businesses and organisations to inform the OFSI if they know or have reasonable cause to suspect that any entities or persons that they are dealing with have links to organisations such as the Central Bank of Russia. We would recommend that the committee look into implementing some sort of similar mechanism in Australia, because early reporting mechanisms would allow for greater compliance, not only with the sanctions regime, but also allow Australian organisations and businesses to more meaningfully connect and engage with the sanctions regime, rather than perhaps viewing it in a sort of fearful manner, given the large substantial fines or imprisonment given for violating sanctions in extreme cases. That would therefore reduce the burden on Australian organisations and companies, and therefore allow for greater compliance overall.
Thank you very much. I'll pass the call to Senator Ciccone.
Look, thanks, Chair. I've only got a few very quick questions. First one with Dr. Anton. Just following on from Senator Birmingham's questions. In your submission on page 6, you speak about the potential gap in our sanctions laws that would allow Australian companies to produce import sanctioned goods overseas, as in outside Australia, and sell them to overseas customers, so non-Australian customers, while remaining in compliance with Australian sanctions laws. Now, are you aware of examples of this occurring?
Yes, well, in fact, the reason why the matter came to my attention, and indeed of many others I would expect to follow this area, is precisely because of a court case that was brought in Australian courts, where an Australian headquartered company, Tiger Realms, that manufactures or extracts coal in Russia, wanted to continue those operations and sought an indication from the Australian Sanctions Office as to whether doing so would be lawful. The Australian Sanctions Office said no, and the company sought to obtain a declaration in the federal court that in fact they would be compliant with Australian sanctions if they continue to extract coal in Russia, but they don't import it into Australia, but sell it to other customers around the world. Now, the outcome of that case in the federal court was that the judge ruled it would not be lawful for that company to continue operating in the way that they do. But the reason for that was rather technical, in my view, and it all came down to the fact that Australian sanctions laws prohibit not only importing import-sanctioned goods into Australia, but also transporting them to anywhere in the world. And so it seems the implication is that if you, let's say, extract Russian coal, and you don't import it into Australia, and you don't transport it to anywhere in the world, but you just simply sell it to customers elsewhere that's not Australia, that potentially could be compliant with Australian sanctions. It seems to be the implication of the judgment. And that is something that is amenable to a relatively quick legislative fix. And the point I'm making in the submission is that if we are trying to constrain the access of, let's say, the Russian regime or the Iranian regime to resources, and we're trying to make it more difficult for them to trade in certain commodities, then it would be nonsensical to allow Australian companies to operate in those countries, extract those commodities, and sell them to somewhere, provided that it's just not Australia and they don't transport those goods. That would not, I think, be compatible with the objective of those regulations, hence the point that I was making in the submission, which, although technical, has come up in legislation, so I think there is some importance to it.
Oh, thank you for that. Now, are there any instances where sanctions are not the most effective way to respond to situations of international concern? For example, where a government is already involved in a bilateral dialogue?
I think there would be many instances. We need to be mindful of the limitations of sanctions, especially targeted sanctions. Targeted sanctions just freeze the assets of certain people and deny them entry to Australia. It can be profoundly significant for those people, or it might be not. In fact, I understand that some of the members of this committee have been sanctioned by Russia, and I expect that not to have had any impact on their lives. The same could happen with Australian sanctions. So sanctions are not a silver bullet by any measure, but they can be an additional source of pressure. And how important that source of pressure is depends on the state of bilateral relations, the broader complex of issues, but also the nature of sanctions. It's one thing to sanction a couple of people on the periphery of a government. It's another thing to freeze the assets of a foreign central bank. So I'm sorry to be providing this unhelpful answer, but the answer really is it depends.
That's right. I'm sure it's a prerequisite now to be a member of this committee to be sanctioned by Russia. But look, and my last question was just to the ANU Law Reform Group in Canberra. Just picking up from your opening statement in the submission, you talked about Australia needing to work collaboratively or strengthen collaboration with like-minded partners. Do you not consider the State of Israel to be a like-minded partner, given that we're the only democracy in the region, in the Middle East?
We don't take a position on the Israel-Palestine conflict. I'd suggest that's perhaps a bit of a charged question. Our submission was more that there should be a clearer criteria for Magnitsky sanctions, and the Australian government has been misapplying it probably on both sides of the conflict, whether that be the Israeli or Palestinian government.
I'll just add on to that as well. The nature of Magnitsky sanctions is that they are individualised. So the sanctions that we have already applied to certain Israeli settlers, they're not towards the Israeli government per se, they're towards individuals. Our point was that they could be much wider in scope. For example, in our submission, we cited a point that said there were hundreds of Israeli settlers that have been reported to be incredibly violent, and yet we've only sanctioned a very small number. I think it's between 7 and 12. I'm not sure off the top of my head. But if we were to implement Magnitsky sanctions more proactively in Israel, it wouldn't necessarily be an affront to the state of Israel, but rather to individuals who were committing human rights abuses demonstrably.
Yes, but when I ask what you mean by like-minded partners, you seem to avoid that question. Do you not agree that the state of Israel is a like-minded partner?
In principle, in the sense that Australia is allied with Israel, they are a like-minded partner, but we didn't take a position on sanctioning the state of Israel per se or working with them. Our point's more about working with other Five Eyes partners in our submission.
And I'd suggest that if we were a like-minded partner, that would also include upholding the rulings of the International Criminal Court, which found reprehensible, abuses of human rights. I think a like-minded partner would probably try and, stand up for the rule of law in that sense and apply their sanctions in a more, perhaps, moral way.
All right, I might leave it there, but I just make the point too, I think there's a two-edged sword here. We've got to be sort of mindful about how we articulate some of these Magnitsky-style laws, considering that their intent was to really go after authoritarian regimes. Anyway, thank you, Chair. I'll hand the call back to you.
Thank you very much, Senator Ciccone. We are a little over time, so we might wrap it up there with these witnesses. Thank you very much for appearing today. The committee would appreciate that responses to questions on notice be provided by Monday, the 2nd of December 2024. I'll ask that you now disconnect from the video conference, Dr. Mosienko. You can continue to observe the hearings through the PALView website. And I'm just seeking a little guidance from the Secretariat as to whether we have all of our witnesses for the next section available. Wonderful. I now welcome Ms. Daniela Gavshon from Human Rights Watch, Mr. Jeffrey Robertson, AOKC, and Ms. Rawan Araf and Ms. Lara Kita from the Australian Centre for International Justice. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you each please state your full name and the capacity in which you appear today? And we will start with Human Rights Watch.
Hello, I'm Daniela Gavshon and I'm the Australia Director for Human Rights Watch.
Thank you, Ms. Gavshon. Mr. Robertson?
Can you hear me?
Yes, we can.
Good. I'm Jeffrey Robertson and I appear on my own behalf, but with Lara, with whom I've written some submissions to you.
Thank you very much, Mr. Robertson. And our representatives from ACIJ?
Good morning. My name is Rawan Araf from the Australian Centre for International Justice.
Good morning. My name is Lara Kadir. I am a senior lawyer at the ACIJ.
Thank you very much. I'll now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions. And again, we might start with Human Rights Watch.
Right, thank you. First, I want to thank the committee members for giving me the chance to appear this morning on behalf of Human Rights Watch. And I'd like to acknowledge the traditional owners of the land I'm on today, which is the Gadigal people of the Eora Nation, and I'd like to pay my respects to their elders past and present. As you all know, Human Rights Watch is a non-governmental organisation that seeks to promote respect for human rights in more than 100 countries around the world. We seek opportunities to promote human rights and we urge governments to hold abusers to account wherever we can. Human Rights Watch advocated for and supported the Australian government's move to pass legislation that authorised targeted sanctions, including visa bans and asset freezes, against individuals and entities implicated in serious human rights violations or corruption. As you all well know, these types of sanctions are important because they specifically target individuals or entities, not the general population, for serious abuses. These sanctions raise the cost of human rights violations by denying abusers entry to and assets in foreign countries where they seek to travel or do business in. For targeted sanctions to have maximum impact, they need to be thoughtfully applied, consistently enforced, and strategically coordinated with international partners. First, I'll talk about the importance of enhancing collaboration with civil society. To foster meaningful engagement between civil society and the government, an effective feedback mechanism needs to be in place between the Department of Foreign Affairs and Trade and civil society groups. While the department has taken initial steps to engage with non-governmental organisations, more structured and meaningful collaboration is necessary to maximise its impact. In particular, once a submission is made, it's crucial that to the extent feasible, the government provides feedback on the outcome and its justification. This feedback should go beyond the current practice of a simple acknowledgement of receipt. Feedback will help build the capacity of civil society organisations to refine future submissions. It will also enable civil society to develop submissions based on an understanding of what material is actually useful to the department and allow for better allocation of limited organisational resources. Second, I want to raise the concern around consideration with other states and consistency. Targeted sanctions should be coordinated to have greater impact. Despite similar policy positioning to countries like the United States, Canada, and the UK, the Australian government often refrains from imposing sanctions on nationals and entities from neighbouring countries, cautioning on regional sensitivities. Instead, Australia's geographical positioning gives it a distinct leverage in Asia-Pacific, particularly as officials from nearby countries often travel to Australia for leisure, business purposes, and elective medical treatment. Banning abusive officials from travelling to Australia on human rights grounds would carry a direct and public personal cost to rights abusers. The government should apply targeted sanctions in a principled, more consistent and transparent manner so that rights violators, even in powerful countries like China, do not evade scrutiny. There are a number of other issues raised in our submission, but the final point I want to highlight are the current gaps in the sanctions framework. Australia's current sanctions framework still does not allow for imposing sanctions in relation to threats to international peace and security and serious violations of international humanitarian law, as outlined in Section 3 of the Autonomous Sanctions Act 2011. This narrows the scope of sanctionable conduct, restricting the Foreign Minister's authority to designate persons or entities on these grounds. Once the government makes an amendment to include its autonomous sanctions regulations, it will have the effect of removing this restriction. Our submission contains a number of recommendations to strengthen Australia's sanctions regime. The three priorities, I'd say, for us are collaborating more closely with civil society and providing more feedback, even if that means in confidence briefings on sanctions impositions. To apply sanctions consistently and in a coordinated manner, including placing sanctions on abusive officials and entities in powerful countries and providing clarity on the reasoning. And the final one is amending 6A of the autonomous sanctions regime to provide meaning to the criteria for these threats to international peace and security and serious violations of international humanitarian law. Thank you.
Thank you very much. An opening statement from ECIJ.
Good morning to you, Chair, and all members of the committee. Thank you for the opportunity to address the inquiry into Australia's sanctions regime. We acknowledge the Gadigal of the Eora Nation, who are the traditional custodians of the land we join you from today. The ACIJ has made 2 submissions to this inquiry. Its primary submission, marked number 12, and a joint submission with esteemed human rights barrister, Mr. Jeffrey Robertson, KC, marked 45. We would like to make a few remarks on these submissions this morning. ACIJ's mission is to seek justice and accountability for victims and survivors of serious human rights violations. We do this by partnering with communities and civil society organisations locally and abroad, working towards developing Australia's role in investigating and prosecuting perpetrators, as well as pursuing other remedies to end impunity. On 31st of March 2020, the ACIJ had the privilege of appearing before the Joint Committee in respect of the inquiry into whether Australia should examine the use of targeted sanctions to address human rights. In our opening statement, We foreshadowed that a targeted human rights sanctions framework would strengthen Australia's capacity to respond to human rights violations globally. We reflect on this statement today, nearly 3 years since the enactment of Magnitsky laws, and wish to highlight that while we have welcomed all designations made under the thematic regime as a step in the right direction, and believe that in enacting Magnitsky laws, Australia laid an important foundation to strengthen its ability to address human rights abuses and corruption, it must be acknowledged that unfortunately sanctions have not been effectively used to penalise perpetrators. Over the last 3 years, Australia has imposed thematic sanctions on 122 targets, comprising 18 entities and 104 individuals. The majority of these are for human rights abuses, with only 14 for corruption and 5 in response to cybercrime. In contrast to like-minded jurisdictions, these figures are relatively low. In our joint submission with Mr. Robertson, we have sought to make the point that perpetrators of human rights and corruption must not benefit from Australia's foreign policy at any given time and fly under the radar of accountability. It is also unfortunate that after almost 3 years, we have not seen initiative to sanction human rights perpetrators in the Asia-Pacific region. The potential ways to deal with the selectivity of Magnitsky sanctions have been canvassed in our joint submission with Mr. Robertson. A final point we wish to briefly address is on the imperative of civil society engagement that could be improved in the designation process. The importance of civil society, particularly with NGOs with specialist expertise in human rights, who have access to victims in diaspora communities in Australia, and fact-finding capabilities enhanced by partnerships with like-minded organisations abroad, cannot be understated. As the Australian co-chair of the Global Magnitsky Sanctions Coalition, ACIJ have the benefit of insight into the level of engagement exhibited in other jurisdictions. Statistics from our US partners, Human Rights First, indicate that approximately 1/3 of US Magnitsky sanctions have a basis in civil society recommendations, highlighting the positive outcome and efficiency that can be achieved in the designation process when collaboration is prioritized. Our submissions propose potential legislative amendments that may be inserted into the present autonomous regime to define an avenue of direct input for civil society. We thank the committee for considering our submissions.
Thank you very much. Mr. Robertson, an opening statement from you.
Good morning, members of the committee. It's good evening for me, but it's been a good evening because I've just come from the annual Magnitsky dinner, where some 300 politicians and human rights officers have come from over 100 countries to discuss the development of this important aspect of human rights. It's a vision of the Andrews Committee back in 2020 that Australia should have a human rights law as a means of holding accountable abusers who couldn't otherwise be prosecuted. So we started with the judges, the doctors, and the policemen who had connived to kill an innocent prisoner in a Russian jail. They were the first even to be sanctioned under Australian law. But contrary to the vision of the Andrews Committee, who wanted an independent human rights experts to recommend sanctions to the minister, well, we don't have any independent human rights experts involved in the process. The Andrews Committee wanted an open process allowing access to diaspora victims and Human Rights Watch and like organizations. But of course, we have a secret process entirely controlled by a department of diplomats now who regard it and say they regard it as a tool, not a tool to promote justice, but a tool of government policy. And this is a fundamental philosophical difference we have. Because historically, diplomats are very often opponents of justice. They are enemies of justice. They always prefer amnesties to international prosecutions. They're always reluctant to condemn allies of ours for human rights abuse. So there is that contradiction, and it may explain why after 3 years, the Magnitsky Law has not been implemented satisfactorily. Well, you've got a phalanx of people from DFAT turning up shortly, and perhaps you should ask whether any of them have any practical experience of fighting for human rights, why don't they answer submissions by NGOs like Human Rights Watch, and why do they still think that this law is simply a tool of government policy and not a tool of justice? And until they do, or some other department preferably takes it away from them, then the public will not approve and will not respect the process. We've made this point in some length, Lara and I, in our submissions about DFAT failures, the failure to target the dreadful death penalty judge in Iran who put Kylie Moore Gilbert, an innocent Australian academic, behind bars for 6 years, the failure to target the two officials who killed Zomi Frankum. It wasn't, as Mr. Netanyahu said, tragedy or tragic mistake. It was a crime, and they were allowed to retire. So our conclusion, with many examples, is that Magnitsky sanctions will never be effective or inspire public confidence unless foreign policy considerations cease to be the driving force, and there is some input from an independent body that is sought and is acted upon. Perhaps, as I say, it will need to be taken away from DFAT. We criticise the department's failure to cooperate or take advice from civil society, so different from its way it's done much more effectively and fairly in America by the US Treasury. And we criticise some of the procedural failures, the absence of a burden of proof, which is in all other Magnitsky laws, the lack of a merits review for those who claim they've been wrongly targeted, and the lack of comprehensible reasons given. Just compare the American statement about the settler they sanctioned and the pathetic little Australian statement about the same man. Finally, let me say a word about the man on everyone's mind, the next American president. I gave a speech the other night to launch a new edition of my book, Crimes Against Humanity, The Struggle for Global Justice, in which I explained how that struggle will be much harder when he revives his previous efforts to destroy the International Criminal Court and brings back the death penalty for federal offences. But I ended with this. I quote myself, "I don't want to be unfair to Donald Trump." Audience laughter. Somewhere in these 900 pages, you'll actually find praise for the way his administration implemented the US Magnitsky Law, Bill Browder's brainwave, supported by John McCain and Barack Obama. The US Treasury sanctioned human rights violators objectively and forcefully, putting the UK and Europe to shame through the power of the US dollar. Carrie Lam, that dreadful administrator of Hong Kong, wailed that after being listed, she had to bring her salary in Hong Kong dollars home in a wheelbarrow, which cluttered up her flat because none of her bank accounts or credit cards would work, thanks to the power of the US sanction. And the US Treasury operates a transparent system, allowing NGOs like Amnesty and Human Rights Watch to nominate violators and denounce them forcefully after detailed investigation. Whether President Trump actually noticed, we can't be sure. But in this respect, if in no other, his first term was impressive for human rights. So all may not be lost even Ambassador Rudd's position. If we make, I suppose, join the struggle with the US Treasury and improve our performance in Magnitsky Law sanctions.
Thank you, Mr. Robertson. I'll now pass to Senator Birmingham to ask some questions.
Thanks very much, Chair. Thank you all for your submissions and your thoughtful opening statements and the work that each of you do, some for longer decades than others, in terms of challenging those of us in the positions that we hold. And even where we disagree or do not act to your satisfaction, it is important that we are challenged on these issues. I guess I want to start by challenging in reply a little and to play devil's advocate, given the strength of advocacy that is being made about the prioritisation of human rights violations in a much more comprehensive way in each of your submissions. And that is to ask what price, diplomatically, economically, should Australia be willing to pay for taking such actions? Obviously, the criticisms you make of current system being used as a tool of foreign policy, implicit in that is that the balance that is considered by those making the decisions is ultimately one that the price may be too high. One can only deduce in terms of the statements the current Foreign Minister made about Xinjiang province and the Uyghur populations prior to the last election, and the absence of them being acted on since, has been some calculus applied within the department or elsewhere. So what price is acceptable?
Well, Simon, if I can answer that, the beauty of a Magnitsky sanction is, of course, that it aims at an individual, not at a government. And so it can always be said, no matter how irritated the individual's government may be, that it is not directed at the government itself. So that is one answer. The other is that, of course, the final decision must always be left with the minister. What minister, who it is, it doesn't matter. It's a government minister. And so if there are imperative foreign policy considerations to weigh up, then they will no doubt be taken into account and be given priority. So it is at the end of the day for the minister and not for a human rights group to take it up. But I don't think that there is or should be a kind of censorship. Oh, we mustn't attack our allies. We mustn't sanction an individual who is a citizen of an ally. We should, on the whole, go ahead if we've got evidence, and there should be a burden of proof that there isn't at the moment, that that individual was engaged in serious corruption or in serious human rights abuse as a perpetrator.
Thank you, Senator.
Did you want to?
Thank you, Senator Birmingham, for the question. I think it's a very interesting question, but from our perspective, the price to pay is by the communities that are affected themselves, and the lack of Australia responding to what we would say would be international obligations to act, where there are serious violations of human rights, and Australia has tools to enact, and in some cases, obligations under international law to respond to those very serious violations. So, you know, while we understand that there are balances that would need to be made, Mr. Robertson clearly pointed out that the purpose and tool and the benefits of Magnitsky sanctions laws is that they are targeted and that they are supposed to target those specific individuals that are responsible for those serious violations of human rights. So that would be our response, is that it's not a price to pay for our country, but the price that the communities affected in the international community not responding itself.
I'd just like to jump in with additional points as well. So I completely agree with what my colleagues have said. The first point being it's the targeted sanctions on individuals, not on a country. The second one being Rwanda's one of the impact on individuals. I think that's the question primarily is, we look at what your question asks what the cost is for the Australian government. We don't know, right? I think we haven't seen Australia being particularly bold around its sanctions. And I think there seems to be a fear about what the cost may be without actually having tested it to see what the cost could be. And so far from sanctions, there hasn't been a significant cost at all from where we sit. And I think, as Rowan said, the cost of not doing it to us seems greater, and the cost of not being strong on human rights is a significant one.
Thank you. And I think my question, yes, of course, there's an element of cost to the Australian government in terms of diplomatic relationship or otherwise, but equally the question was really seeking potential cost ultimately to the Australian public, if indeed, to take that China example, the government perhaps had taken a different course in relation to application of sanctions, which equally may have resulted in a different course in relation to the stabilisation of the relationship and the removal of trade sanctions applied against a range of Australian industries. And obviously, I think as Mr Robertson said, leaving ultimately the decision to a minister means that in any scenario, there will be a question where those balances are considered. One of the reasons why I wanted to instigate this inquiry, though, was to think about how those issues perhaps can be mitigated. Parts of your evidence in relation to the role of civil society, the transparency of processes go to that. I also am keen to touch on how we have a more efficient system of collaboration and assessment with other partner nations. In the end, the world is not a very nice place in lots of circumstances. The list of individuals that could be sanctioned theoretically is enormous, and the resources that government physically can put to those assessments under current laws as they are structured is always going to be finite. So how, in terms of the better use of civil society, but also the mutual recognition of at least assessments possibly undertaken by partners, the sharing of that information, perhaps even the joined up or collaborative assessments that are undertaken, such that we don't have a system where Australia and our partner nations are all simply duplicating resources to assess the same human rights abuser or other violator of the grounds that we deem reasonable to sanction?
I think that's a very good question because, let's face it, the United Nations was set up to stop the scourge of war, it says, and it's useless for that purpose because the General Assembly is a talking shop and the Security Council is fatally divided thanks to the veto power that three countries hold. And so it's impossible, even if Russia were to drop a nuclear bomb on Kiev, they wouldn't be expelled from the United Nations because it would veto its own expulsion in the Security Council, just as America vetoes any resolution for a ceasefire in Gaza. So it is not, it has led many people at the moment around the world are talking about alternatives to the United Nations, much as they talked about alternatives to the League of Nations in 1939. And H.G. Wells and others argued then for an organization of parliamentary peoples. And that, of course, was impossible once Stalin brought Russia into the war and it became our great ally. But there is a lot of talk about marshalling the 130 odd countries that have signed up to the International Criminal Court as a new force in the world with its own court and so forth. I won't go into it. But what you're saying, Simon, is part of the discussions that are starting. And it's very important that Australia should be part of them, that we should be talking to Europe in particular, which will take on a greater role if Trump does withdraw, and to combine our power. Obviously, Australia has more interest in the Pacific and Europe in the East. But it's time that there was a combination. It may be, particularly if Trump does try to destroy the ICC, it's very important that we have a connection, strong connection with Europe and with Britain and Canada in order to protect and advance the interests. And it is the one area where we can rely on sensible American support. So that's an initiative that I think it would be terrific if Australian politicians like yourself took.
As I understand it, Senator, there's 2 points to your question. I'm going to address the first one about a better effective use of NGO engagement. Currently, as my colleague Daniela Gapsham from Human Rights Watch pointed out in her opening statement, and which is canvassed in all of our submissions, although the Department of Foreign Affairs and Trade has some form of engagement with leading civil society actors like ourselves, we do think that in comparison to how our colleagues are engaged with their respective departments abroad, that it could be much more effective and they could utilise our role and our referrals and our networks and expertise in a much more effective way and a much more structured way. I can tell you that our own recommendation is that a formal legislation could specify a clear route for civil society submission, but we've provided an alternative if legislation to introduce, if there is no ability to introduce legislation in that regard, there should still be better guidelines on how DFAT engages meaningfully and effectively with NGOs. Just to give you some examples, our colleagues abroad in the UK and the US jurisdiction, for example, regularly engage. They are provided with regular feedback on their submissions, on what is required, and their regular meetings. So that is in stark contrast to our experience here in Australia, which is very frustrating for us, as we provide a lot of input and research into the submissions and the referrals that we provide. We simply only get an acknowledgement response. And that, unfortunately, is unsatisfactory. And our colleagues abroad are also of the view that, that's not a system that values civil society engagement in any way.
Can I just build on that point? What I would sort of add to what Rawan has said is that, when your question asked about sort of maximising, state resources, knowing that, having, countries work together is important because there is a finite amount of resources. In the civil society sector, our resources are minute by comparison. So when you think about the resources it takes for all of us to put in submissions, if we can coordinate with each other, but if we're not coordinating more clearly with government in a way that actually, as Rawan says, gives us that feedback on how we're doing, it really is a waste of incredibly limited resources. And the idea should be that we should be seen as partners who can help provide with the information, because we do have information on the ground and have access to information that government doesn't have. And so if we really want to leverage that, then that feedback loop is crucial.
Wonderful. Senator Ciccone, I believe you have some questions for these witnesses.
Just the one. I just wanted to ask Mr. Robertson, with the submission that you provided, the way I read it, you take issue with DFAT's description of sanctions as a tool of statecraft. Would you be able just to detail for us what are some of, I guess, alternative foreign policy tools that might be available to government?
Sorry, I can't hear you. Would I be able to?
Is that better?
Yes.
Yeah, okay. In your submission, you take issue with DFAT's description of sanctions as a tool of statecraft.
Yeah.
Given this, hoping you might be able to detail for me in the committee what are some alternative foreign policy tools available to governments to respond to situations of international concern besides sanctions?
Well, I think the problem, and you look at it with 3 years of assessment of very little done, except in relation to Iran and Russia, nothing much with China, and none in relation to perpetrators of abuse that can well be found in America. So there is a concern that by making it a tool of foreign policy and by making government policy the dominant concern, that you never look at a human rights abuser from an allied country. You never consider the abusers that come from our friends. You perhaps go along with condemnations of the International Criminal Court, although Australia has been very supportive of it to date. But you don't hold with the idea that human rights abusers should leave the stage with an amnesty in their back pocket and a Swiss bank account intact. This is the way diplomats think. It's not the way human rights aficionados think. And so that is where diplomacy and human rights come into clash. And I think it reduces the significance of the Magnitsky Law if DFAT gives a shoulder-shrugging statement, oh, it's just a tool of our foreign policy. It's not. It's a tool of justice aiming to deter people, particularly people like lawyers and doctors and policemen and state officials acting contrary to international law from acting in that way. So that's why it's important to change the philosophy we think of DFAT and actually set it off on the course that Bill Browder and Barack Obama and John McCain envisaged it back in 2012.
Thank you. I want to get contentions that government should do a lot more to coordinate, collaborate, and harmonise sanctions with partners and allies.
Yeah.
Might be here for Dorothy Dix of this one, but what would be an ideal model of coordination, collaboration, and harmonise? What would it look like from your perspective?
Coordination, and for example, tonight we had 300 people who are politicians and human rights lawyers and the like, aid workers, discussing the way forward. And in each country which has a Magnitsky Law, and there are now, I think, about 36 or 7, and others on the way. Even New Zealand, I'm told, is about to catch up. But it would mean that there would be appointments from the departments of government that are relevant, if they're who would meet by Zoom, preferably, but at least regularly, to update their submissions to ensure that they were sanctioning the same people. And of course, we give an example, Lara and I, in our paper of a US Treasury sanction of an Israeli settler who's been killing Palestinians, and the Australian sanctioning of the same person which is utterly pathetic and gives no information. The US sanctioning comes with an indictment, and that's how it should. So there are lots of gains, I would think, if they met, if they organized, if they had perhaps an executive with a leader and a secretariat and so forth. It would be the next step. It's one that we are talking about. That's true, but it needs not even the charisma of Bill Browder, but it needs the support of a sufficient number of governments to put it in place.
Thank you very much. I'll leave it there, Chair.
Thank you, Senator Ciccone. Given it's pretty close to 10:30, we will wrap it up there. The committee would appreciate that responses to questions on notice be provided by Monday the 2nd of December 2024, and thank you to the witnesses in this section of the program for appearing this morning. I would ask that you now disconnect from the video conference, and if you wish to continue watching the hearing, you can do so on the Australian Parliament's website. But the committee will be taking a short break now and will resume at 11 a.m. Thanks all.
Thank you, Senators. Thank you. Bye-bye.
Bye.
I think we should be fine. The committee will now recommence our hearing into Australia's sanctions regime, and I welcome Mr. Andrew Mechinsky from the Ukrainian Council of New South Wales. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
My name is Andrew Mensinski, and I am appearing as the Vice President of the Ukrainian Council of New South Wales.
Thank you, Mr. Mensinski. I'll now invite you to make a short opening statement, and at the conclusion of your remarks, I will invite senators to ask you questions.
Thank you. Thank you, Senators, for allowing me to appear today on behalf of the Ukrainian Council of New South Wales. Firstly, I'd like to say that the situation in Ukraine remains very challenging. For almost 1,000 days, Ukraine has bravely resisted Russia's brutal, illegal and unprovoked invasion. Just yesterday, Russia unleashed a massive missile attack upon many areas in Ukraine, including the capital, Kyiv. In the last few weeks, Russia has launched nearly 100 missiles, around 600 drones, and more than 1,000 guided aerial bombs at Ukraine, killing at least 50 civilians and injuring hundreds more. The Ukrainian community here in Sydney, and in fact Australia, including many displaced Ukrainians, are grieving this heinous loss of life. I'd also like to inform the committee that since the start of the full-scale invasion, over 140,000 war crimes by Russians have been registered in Ukraine. Over $700 billion of damage to Ukrainian homes and infrastructure has been caused. Over 3,800 educational facilities and over 1,500 medical facilities have been damaged or destroyed, and more than 20,000 Ukrainian children are confirmed to have been kidnapped and deported to Russia against their will. Now, these atrocities don't come cheap. The existing sanctions regime, while a good starting point, has not it's fair to say, done enough to curtail the funds that fuel Russia's war machine. It is the position of the Ukrainian Council of New South Wales that Australia's sanctions regime must be strengthened to enable greater deterrence on Russia's ability to continue its aggression. In its submission, the UCNSW proposed 8 high-level recommendations. Now, I won't read them out in full, but I would like, however, just to summarise them under what I've just coined the 8 C's of sanctions. So 1, consistency. I think Australia should align with our closest allies to ensure that sanctions are applied in a timely and consistent manner. This reduces sanctions arbitrage, where sanctioned individuals can shift operations here to Australia potentially to a less stringent environment than they may have elsewhere. 2, consequences. We should expand our Magnitsky-style sanctions further to target individuals who have committed human rights abuses. Significant economic and legal consequences need to apply to hinder those individuals' ability to operate and generate additional funds for Russia's war machine. Thirdly, coordination. Our researchers found it difficult in preparing their submission to this committee, partly because there is a lack of internationally coordinated information. It is our recommendation that Australia can take the lead in international coordination of sanctions by developing a sanctions database that enables sanctions tracking across multiple jurisdictions. With this database in place, this will enable easier research, but also will assist in reducing the sanctions arbitrage that was mentioned in point 1 earlier under consistency. Fourthly, confiscation. This is a really key point in our submission, one that I would like to spend some time on today. Australia should implement sanctions measures similar to those in the UK, which provide for the freezing, confiscation and redirection of assets belonging to sanctioned individuals and entities. Of the $500 billion of frozen Russian assets, approximately $10 billion reside here in Australia. Fifth, clarity. The Australian government should engage more proactively with civil society and the private sector and provide better access to sanctions data and resources. As I mentioned earlier, our researchers did find it hard to find information on the current sanctions regime, and I think some clarity here is required, improved clarity, so people know what's in place and therefore can make meaningful suggestions as to how the environment can be improved. 6, communication. You can't manage what you don't measure. Australia should establish a formal process for assessing and reporting on the effectiveness of Australia's sanctions regime. This could include regular reports to Parliament, regular reports on departmental websites. It could include consultation with affected communities. However, a set of independent metrics that can demonstrate the effectiveness or otherwise of Australia's sanctions regime. Point 7, corruption. Australia should strengthen the alignment between its sanctions regime and anti-corruption measures. This will ensure that individuals or companies that in and of themselves are not sanctioned, however they facilitate sanctioned activities, are held accountable under anti-corruption provisions. And finally, point 8, context. Australia needs to be flexible with its sanctions regime and adapt to shifting global dynamics. We at the moment are in a period of immense global turmoil. Apart from sanctioning Russian individuals and entities, Australia does need to work with its regional allies to ensure that sanctions also contribute to stability and security in our own Pacific region. In closing, it is the view of the Ukrainian Council of New South Wales that by taking a leadership role in this space, Australia can make a significant contribution to international efforts to hold Russia accountable for its barbaric actions in Ukraine. Thank you.
Thank you, Mr. Masinski. Senator Birmingham, you have the call.
Thanks, Chair, and thank you for your submission and of course those of other organisations representing the Ukrainian community in Australia, and do appreciate pain that community's been going through the last couple of years, but also the leadership that so many figures have shown in their advocacy during that time. I'd like to focus in perhaps on a couple of the C's that you've identified in your submission, in your opening statement, especially confiscation and corruption. But perhaps just before I get to those, in the community's understanding, are there other systems, other countries that you observe or through your networks, your other partners indicate are more effective in the way in which they, in a timely manner, are able to quickly enact and make decisions around the sanctions that are applied and have been applied against Russia? And if so, what are the factors to your understanding that enable them to be more timely and that could be applicable to help Australia's system be more timely in the way in which we make such decisions?
Thank you. I think in our submission, a particular reference was made to the UK system. I think the UK Sanctions and Anti-Money Laundering Act seems to set out a series of financial provisions which are further reaching than those that we do have here in Australia. Under this particular SAMLA Act, we have seen, while symbolic, the seizure of yachts from Russian oligarchs and other items which can then be sold, and those funds can then be used to assist Ukraine, whether it's in humanitarian aid or for the provision of further weapons. So I think if we were to say, well, who's the leader in this space, it would probably have to be the UK and to an extent the US as well. We have found that when there were gaps, the gaps always seem, in terms of where that sanctions arbitrage that I mentioned earlier, the gaps existed where Australia was not sanctioning individuals that were sanctioning the UK and the US. I think in early 2020, mid-2022, and I believe this has been closed up somewhat, there were 50 Russian oligarchs, known close associates of Putin, funding the war machine that had still not been sanctioned by Australia and had been sanctioned by other jurisdictions. Oleg Deripaska is an absolute case in point, one where really has been, I think he's been struggling in many ways to try to set up numerous trust accounts and shell companies to try to retain his assets. So I think here, this is something where we would hope that Australia could act just more vigorously, especially when other jurisdictions have called out that there are people that deserve to be sanctioned. We just expect Australia to really act rapidly and in alignment, so we just close that gap when it gets identified.
Thank you, and obviously part of that goes to your submission around coordination, but sort of lean into that coordination around the enforcement side and how that leads on to potential for confiscation, but coordination around enforcement and understanding of what assets there are and how sanctions are actually enforced. What is your assessment of the adequacy of that, and where do you think there are risks in relation to Russian assets being held in Australia and not having been identified by Australian law enforcement or regulatory agencies?
It is deficient, the current situation. Our researchers spent inordinate amounts of time collating lists of assets and sanctions and cross-referencing them against each other. So I think I'm not entirely sure if it's the answer to your question, but this is one of the items that we're calling for, is for governments to step up and take this role rather than private individuals scouring websites or sanctions websites of various jurisdictions and trying to create connections between them. But there is one standardised global database which lists assets held in jurisdictions, individuals sanctioned in numerous jurisdictions, and then can quickly call out the gaps within them. And that's something that we would hope that Australia, if anything, could take a leading role on and suggest this can be done. This is fundamentally, at its heart, can be a technical solution. This is something that Australia has the capability to deliver.
Thank you, and obviously that is a big piece of coordination if it is to involve global overlap. Are there instances that your organisation, your volunteers are aware of assets held in Australia that may not have been identified by AFP or other agencies tasked with looking at the extent of those assets?
I would have to take that question to our experts. I have not been made aware of any. In the reports that have been delivered to us internally, it hasn't been identified that there are undeclared or unidentified assets. However, that being said, I'm not sure. So if the committee is open to that, I'm happy to provide an official response after this discussion.
We heard in some of the earlier evidence views and comparisons of the strength of clarity from some other governments about the need to pursue confiscation of assets, to move from that freeze to seize positioning, which is obviously your part of your submission there in terms of confiscation. What scale of confiscation do you think should be pursued? How do you assess or consider the trigger points that governments in setting in place frameworks for when they do move from freeze to seize should be considering? And in the case of Ukraine at present, how urgent do you see it for Russian assets to be seized and to have those funds made available to Ukraine?
The urgency cannot be overstated. Ukraine is in desperate need of financial support as well as military support as well. As I mentioned before, the total value of frozen assets is approximately $500 billion US. So let's call it 750 to 800 billion Australian. Now that dwarfs the support that Ukraine has received from all of its Western partners, Europe, America, Australia, and others. So, and Ukraine desperately needs that. I think to pay wages, to pay for civil society, to pay wages for the military, to purchase weapons that are available for purchase. So the need is absolutely intense. Ukraine's GDP is, of course, reduced. It's very hard to have a functioning, robust, growing economy when, as I mentioned earlier, missiles are being rained down upon infrastructure on fundamentally a daily basis. I think if you were to ask me when the trigger point, I think the trigger point would be when an individual is sanctioned. I think at this point, after 3 years, almost 1,000 days of the full-scale invasion, there is no reason to wait any further. Any individual that is complicit and has been sanctioned, has been found complicit in contributing to Russia's barbaric actions on Ukraine, their assets are forfeit, and they need to contribute towards just a rebuilding Ukraine and continuing Ukraine's resistance. So, as I said, the 5-second version is what's the trigger point? The trigger point is now. The trigger point is immediate. Upon sanctioning, any assets are immediately subject to confiscation and for redistribution to assist Ukraine resist and then rebuild.
Thank you. Some of the submissions, including across the Ukrainian submissions, have identified legislative gaps around the import sanctions goods which need to be closed. What are the nature of those gaps, and what concerns do you have about where Russia may still be able to derive income or opportunity from from gaps in the Australian sanctions regime?
Unfortunately, I don't possess the. I'm not in a position to answer that question with any degree of confidence. I'd be speculating, so I'm sorry. May I decline to answer that question?
No, that's fair enough. I understand. In terms of an important point you made amidst your Cs that does exist in other submissions, but which we haven't touched on in the public hearing so far today, is that alignment with corruption legislation. Of course, many people think of our application of Australian sanctions purely in the context of individuals offshore. What is the importance that you're placing in relation to that alignment with corruption legislation as to how that can provide greater consistency for how sanctions are enforced, greater powers or scope in relation to the enforcement of them, and also potentially where it does bring into scope those who may play a role in the evasion of sanctions?
I think Russia has proved itself to be quite adept at avoiding sanctions on domestic and global levels. We've seen with the shadow fleets going around the world, shipping Russian oil to all over the globe. Russia is able to fundamentally, I think, bribe people or dangle huge sums of money in front of individuals to assist them in breaching or avoiding sanctions regimes. And this, I think, is where the anti-corruption provisions come into play, because while as an individual, this person may not be sanctioned an individual, and let's use the example of oil, someone that assists then with shipping that oil, someone that assists with placing that insurance for those ships, someone that assists with finding sailors to man those ships is directly contributing towards the evasion of those sanctions. And I think it would be probably very challenging to sanction those individuals themselves for items they may do within their regular course of business. However, the anti-corruption provisions would provide a deterrence to those individuals from participating or from doing that, because if they were aware that there were consequences that could apply to them for their actions in assisting or facilitating sanctioned activities, this may stop that. I think obviously there's the core of the web. There is the core of the sanctioned activities, and there's all the facilitating activities around it. Extending and strengthening anti-corruption provisions freezes that web as well as freezes the activities and just makes it harder and harder to do. And so I think that's where we see that, and we recommend that some effort be applied to this. So the ancillary players that think, well, I've got an opportunity to make some money here, may reconsider that and think, well, okay, I may make some money, but that may be forfeit and I may be subject to significant consequences, and may make them change their minds. In short, we're looking for anything that will stop people assisting Russia killing Ukrainians, and this is an area that we think is worthy of further investigation.
And can I just ask, thank you for a little elaboration on your last C, context, and in the eyes of many, the decisions in relation to sanctioning Russia, deciding to go harder on Russia, pursuing confiscation, all of those factors should actually be relatively straightforward. Relatively straightforward for a number of reasons. The alignment of values in this case in terms of the respect for sovereignty, the blatant breaches of international law that Russia has engaged in, huge cost and toll that's applied, but also relatively easy in a crude sense because Australia's equities with Russia are relatively low compared with our equities with other major countries, including some of our nearer, larger trading partners, for example. So when you speak of context in the global environment, how do you see the need for Australian governments in terms of achieving that balance of context, in terms of being considerate of ultimately the price and the consequences for Australia potentially and Australians in terms of where and how sanctions are applied and what the repercussions of those sanctions may be for Australians?
Australia is and has been a defender of freedom and of democracy. And this is why we have these sanctions, while we're applying sanctions against, as I said, against Russia. However, I think we are seeing a rise in authoritarianism. We are seeing a rise in potentially, dictatorial countries, and we're seeing that in our Asia Pacific region as well. I think the point about context is saying that authoritarianism is on the rise everywhere. It's not just in Russia. Russia's authoritarianism emboldens authoritarianism in other areas, whether it's China, whether it's Iran, whether it's North Korea. If Australia acts promptly, and I think most people would realise that rise in authoritarianism has direct future consequences for Australia. So it is the obligation of Australia, it behoves Australia to think strategically and to use sanctions to shape behaviour and to stop authoritarianism wherever it occurs. And this is the reason for that context. So yes, we want to see sanctions against Russia, but we would also see sanctions against players that operate in our hemisphere, in the Pacific region, that also exhibit authoritarian tendencies, and therefore Australia sends a clear message to those authoritarian countries that this is not behaviour that Australia will tolerate. This is not a behaviour that Australia will stand by and just watch, and there will be consequences for that behaviour. It is when there is a consistent and united front against all examples, all authoritarian behaviours, I think that sanctions work most effectively. And if other countries also then stand with us, and we do have a coordinated global sanctions approach, this is a weapon that the West can use, and a non-lethal weapon that the West can use to shape behaviours and hopefully return to a rules-based liberal democratic method of functioning, which is the way that Australia operates and the way that has provided peace to the world, for relative peace to the world for the last 80 years. So that's what I mean by context. Now, there are consequences. Of course, there's consequences for all of our actions. However, back to the short point, there are short-term economic consequences and there are long-term security consequences. And I think that the long-term consequences need to be weighed up and need to have greater weight than potentially a short-term economic benefit or economic consequences.
Thank you.
Thanks, Senator Birmingham. Senator Ciccone.
Thanks, Jill. I'll be very quick. Just picking up on that last answer and question. Can I just ask then, are there any other ways that governments can articulate in its rejection of Russia's actions that are just as effective as sanctions, from your point of view?
One item that the community has long called for is the expulsion of the Russian ambassador as well as Russian diplomatic staff. The Russian ambassador, and as we all know, that the criminal, Simeon Boykov, who's hiding in the embassy or the consulate here in Sydney, they are a stream of misinformation, of provocations, of aggression against the local Ukrainian community and attempts to undermine Australian democracy. We believe that the Russian ambassador should be declared persona non grata. All Russian diplomatic staff, who fundamentally are employees of the FSB, the Russian security services, should also be declared persona non grata and should be asked to leave the country. The concept that back-channel diplomacy is required to achieve change or to achieve change in Russia's actions has unfortunately proven itself to be futile over the last 3 years. So let's take a stronger step here. Let's take a stronger stance and say, okay, Russia, you're refusing to sit at the table of civilised nations. And there are consequences for this. There are economic consequences and there are diplomatic consequences. You have no presence here. I would also argue that, and we have called in the past, that we should block entry to Russian travellers here, to Russian students. I think that Russians are free to leave Russia and to travel the world and to do whatever they want. And we find that is incredibly unfair. Ukrainians are pinned down. There's no airport in all of Ukraine. They cannot fly out of the country because they're at risk of being shot down. So the fact that Russians have this freedom to travel globally, whereas Ukrainians are imprisoned under a barrage of missiles, we feel is absolutely unfair. And one thing that we think can be done is we block the ability of Russians to visit here, to come on holidays, to study, and to enjoy freedoms that Ukrainians are denied. So I think apart from the sanctions, I would call for the immediate expulsion of the diplomats and also a cessation of visa programs, a denial of visas for visiting Russians to Australia.
And just lastly, one of your recommendations, number 5, says that the government should engage more proactively with civil society and private sector, providing better access to sanctions data and resources. Now, what kind of data and resources would you like better access to?
Look, that's probably a question I'd need to come back specifically. I think that was a feedback from our researchers, was they said they just found it very difficult to get access to the information that they needed to prepare the report. Probably that's the next level of detail, what exactly they found it difficult. But the recommendation from the researchers was, look, maybe rather than us having to dig for this, if this could be proactively provided in a more accessible fashion. So I'm happy to provide some specific recommendations as to how this can happen.
That'd be great. Thank you. Thanks, Chair.
Thank you very much, Senator Ciccone, and thank you, Mr Mizzinski, for appearing before the committee today. We would appreciate that responses to questions on notice be provided by Monday, the 2nd of December 2024. And I'll ask that you now disconnect from the video conference, and if you want to continue watching the hearing, you can do so on the Parleview website.
Okay. Thank you for the opportunity.
Thank you. And we'll now move on to the next section of the program with various government departments, if they would like to come up to the table, please. We have everyone there? I think so. I now welcome representatives from the Department of Foreign Affairs and Trade, the Department of Home Affairs, the Australian Federal Police and the Attorney General's Department. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, will you please state your full name and the capacity in which you appear today? And we might start with the witnesses who I think are from the AFP at the end of the table and work our way along.
James Ryan, Superintendent, Customs Enforcement with the Australian Border Force.
Yeah, Tony Smith, the Assistant Commissioner of Customs Compliance Enforcement and Targeting with the Australian Border Force.
Anthony Maguire, Acting Commander for the AFP for Cybercrime Operations.
Julia Heckscher, First Assistant Secretary of the Regulatory and Legal Policy Division in DFAT.
Bronte Mills, Assistant Secretary, Human Rights Branch and Ambassador for Human Rights, DFAT.
Nina Harvey, Assistant Secretary, Office of International Law in the Attorney General's Department.
And Mr Rice on video conference.
Thank you. Acting Assistant Commissioner Anna Rice for criminal assets confiscation, and my substantive role is the Commander of Economic, Corporate Crime and Corruption, which has a touch point here.
Thank you very much. I'll now invite you to make a short opening statement, and then we'll ask members of the committee to ask questions. Might be easiest if I ask, does anybody have an opening statement they'd like to make?
Thank you, Chair. Tony Smith from Australian Border Force.
Thank you.
Chair, committee members, thank you for the opportunity to provide this opening statement. The Australian Border Force is Australia's frontline border law enforcement agency and customs service within the Department of Home Affairs. In respect of Australia's sanctions regime, the ABF is responsible for administering sanctions-related import and export prohibitions under the Commonwealth legislation, including Customs Act 1901, the Customs Prohibited Import Regulations 1956, and Customs Prohibited Export Regulations 1958. Collectively, these give effect to aspects of Australia's obligations, such as United Nations Security Council imposed sanctions, as well as Australia's autonomous sanctions. The ABF works in partnership with domestic and international stakeholders to share knowledge, information and expertise that protects the Australian community through detecting, deterring and disrupting the movement of sanctioned goods, including through coordinated intelligence and enforcement actions. The ABF draws upon whole-of-agency resourcing to implement import and export prohibitions, including through a dedicated end-to-end sanctions enforcement function. This function received funding of $1.2 million over 4 years from 24-25 and $300,000 ongoing from 28-29 to provide resource uplift that is now responsible for enforcing border-related sanction obligations, working across the enforcement lifecycle, including targeting, analysis and criminal investigations. The ABF supports sanctions-related outreach activities with industry, research and academia and the private sector to ensure associated border obligations are well understood within the community. We also engage internationally to reinforce the government's global commitment to upholding sanctions, including through the release of joint products that raise awareness on risks associated with certain activities, such as industry guidance issued under the Export Enforcement 5. I am grateful for the continued support of the regulatory, intelligence and enforcement partners and the dedicated ABF officers responsible for sanctions enforcement. Thank you, Chair and committee members, for your time today. I'm accompanied today by Superintendent James Ryan from the Australian Border Force Counter-Proliferation Team, and we welcome any questions.
Thank you very much. Any further opening statements?
Thank you, Chair. Julie Heckscher from DFAT. We thank you for the opportunity to present evidence to the committee today. We welcome the opportunity to have a discussion about the sanctions regime, which has grown in both volume of listings and complexity in recent years in response to the challenging global environment in which we operate, as well as the increasing challenges the UN system faces in responding to situations of global concern. The use of the Russian veto, for example, recently to prevent the renewal of the DPRK monitoring panel was just one example of that. The Department made a submission to the inquiry which aimed to provide hopefully a helpful outline of the way in which our sanctions operate in both UN Security Council sanctions and our autonomous frameworks and the approach that the government takes. But having had the benefit of listening to some of the evidence given to the committee this morning, I thought it might be helpful to touch on a couple of the issues that came up in slightly more detail. They are key points of the way that we implement sanctions in the Department of Foreign Affairs and Trade. The first is the role and the use of sanctions. And sanctions are, of course, not an end in themselves. It is often very easy to call for sanctions, and they are an important tool to respond to egregious actions, to try to deter, to impose costs, to send signals. But they are only one tool. They're not always the most appropriate, they're not always the most effective, and they're complex. They're complex to apply, they're complex to comply with, they're complex to monitor, to enforce, and they impose costs beyond those intended for the target of the action. We give careful consideration every single time we impose a sanction. And some of the things we take into account just for broader awareness is, of course, the objective. What's the objective that we're trying to achieve? We have other levers and other tools we can use, Are sanctions the most effective tool? Should we try other levers in advance of sanctions? Should sanctions just be part of a consolidated strategy? And should we actually partner up with other countries? So what are other countries doing? Cost and impact. There are, of course, costs and impacts intended for the targeted audience, but the costs will actually be borne by the Australian community. And it's important to remember that sanctions are effectively constraining action by the Australian community. Australians and Australian community actually have to comply with sanctions. They have to undertake due diligence. They potentially lose supply chains, lose markets and the like. And we have to take into account what those costs might be. So not just the intended impacts, but the costs on Australia and Australians. We also need to take into account unintended impacts of sanctions. For example, unintended impacts might be on other countries in our region, the local communities who may be not the intended target, but impacted nevertheless. And things like impacts on humanitarian supply and the like. So sanctions, really just to reinforce that sanctions are a very, very complex tool. Once we have them in place, we also have to monitor and enforce compliance. And we collaborate very closely with partners here at the table and with AUSTRAC, not here, but it is nevertheless a complex task. The second point, which was raised in a lot of evidence this morning, was coordination of effort. To what extent do we engage like-mindeds and work with like-mindeds? Now, clearly, sanctions only work as a whole-of-government enterprise, and we very much value the way in which we work closely with partner agencies. This is critical to our ability to monitor and enforce compliance and pursue non-compliance. We also have to engage with partners overseas, and this was a question that came up quite a lot this morning. We engage all the time with partners overseas. I think the ABF already mentioned that they coordinate with their partners, we coordinate with our partners. We participate in many groupings, Five Eyes at different levels, the Repo Task Force, which is Russian elites, I always forget the P, and oligarchs kind of grouping, which is where we collaborate with the US, the UK, the EU, Canada and others on sanctions targeted at Russian elites. We work closely in EU groupings. We have bilateral conversations. Just earlier this week, we had one of my team sitting in on a call with G7 on enforcement operations at midnight, I think it was, and then another meeting the next morning at something like 5 a.m. talking to Five Eyes partners. There is a huge amount of coordination of intelligence sharing, of evasion activity, contraventions, effectiveness, impact. Another issue I wanted to just mention is the sanctions use and the sanctions context is constantly evolving. In just the last couple of years, the number of sanctions that Australia has nearly tripled. And it's tripled in volume and increased in complexity. If we give as an example for the oil price cap, for example, which was a relatively innovative, creative sanction that was intended to impose a cost on Russia whilst not impacting other countries and energy supply globally. We were part of the oil price cap grouping that worked that through. But it is a complex sanction. It's complex to apply, it's complex to enforce, and as we've seen more recently, there's complicated and sophisticated evasion that is underway. Fourth, I would mention challenges flowing on from the complexity of the sanctions use and the expanding use and the increased sophistication of evasion and contravention efforts. This is part of the big challenge that we face. How do we keep our sanctions regime live and up to date? We had a legislative review, which may well come up in questioning, that is intended to enable us to actually update our sanctions regimes. But of course, they are constantly under review. We will constantly tweak to add more provisions to make sure that it is robust, defensible and the like. Enforcement and compliance, which was mentioned by ABF as well, that is a critical piece of the sanctions workload, and that has got more difficult. We secured government funding earlier this year to lift the monitoring, compliance and enforcement workload, and we can go into that in more detail. But that is part of the challenge of sanctions, and it is one in which we are working closely with other agencies. Those are the key points that I wanted to make just at the outset, almost to frame the conversation that we're going to have. I do have with me from DFAT a number of colleagues on specific areas as well. I did want to note at the outset that unfortunately we don't have anyone from our Middle East area as they're travelling. As you can appreciate, the crisis has meant that we have a lot of people working on that issue non-stop. But I think Middle East issues were covered in a great amount of detail in our estimates appearance pretty recently, and we can take questions on notice. Thank you, Chair.
Thank you, Ms Heckscher. AGD, opening statement?
No opening statement from us, thank you.
Wonderful. I think that's everyone then. Great. I will hand to Senator Birmingham for questions. Thanks.
Thanks, Chair, and thank you all for your submissions, attendance today, and those who've made opening statements and indeed your contribution in this area of important policy. Perhaps just to start with a few little processing questions and directed, DFAT in particular, to the work of the Australian Sanctions Office. How many ASO do we have currently committed and working full-time on sanctions application and enforcement?
Thank you, Senator, for the question. I actually have the staffing details. I think you'll probably appreciate that sanctions issues constantly come up, and so we move some of our sanctions staff from crisis to crisis, from issue to issue. But as of 14th of November 2024, the ASO has 23 staff, excluding the senior executive staff, 7 staff working on sanctions compliance, 5 working on permits and outreach, 6 working on sanctions strategy and legislation, and that's a lot of that is actually to do with engagement with partners offshore as well. 5 staff working on sanctions listings and litigation. So hopefully that helps with the response. Sometimes if a particular issue comes up and we need more people to work, we will move people, across as we need to respond quickly.
Of course, thank you. And how has that varied over recent years?
Well, that's a very good question, Senator, and I will have to take on notice exact details. I have the current staffing, but not previous staffing. I will note that as a result of the increase in budget that we secured out of this year's budget for over the forthcoming 4-year period, we secured 23.5 ASL. We also secured out of that budget funding some ASL for ABF, AUSTRAC and for the CDPP as well. Those staff, who we're still recruiting, by the way, will essentially help us do a number of things. They will help us focus on compliance, monitoring. They will help us set up, start to set up a more comprehensive monitoring function within the Australian Sanctions Office. If I can go slightly backwards and note, as I said in my opening statement, the sanctions environment and sanction framework globally have shifted a lot since Russia's invasion of Ukraine. The complexity, the number of listings and the like. The kind of monitoring that we need now, given the kind of sophisticated contraventions that we are seeing globally, has meant that we need to actually do more in the monitoring and compliance space than we had previously had to do. So that part of it will actually enable us to step up that function. Some of the things like giving us some more tools to actually track things. We work very closely with AUSTRAC, for example, on tracking financial transactions. However, it will enable us to have a greater set of tools in which we can engage on those, on that monitoring function. The consolidated list, some of our lists could really do with some improvements. So actually improving some of that material, increasing outreach and the guidance notes that we provide to help the regulated community in Australia comply with sanctions and to help them when there were difficult questions. It will also help us with that, and we have stepped up that work already. So those are some of the things that we will do once we fully fill all of those positions.
Thank you. Just in terms of the compliance and monitoring space, can you provide a clear understanding of where the responsibilities lie in terms of investigating potential sanctions evasion, sanctions breaches, the role of the ASO versus AFP or others in terms of the identification of assets and steps that theoretically should be undertaken where such assets or breaches are identified?
If this is, as I understood the question, you want to focus on identification of assets as opposed to general compliance. Is that correct, Senator?
No, I said identification of assets, but breaches of sanctions in general as well. So if we can understand where the delineation occurs on each of these fronts, please.
Certainly. Hopefully I can help, and I will defer as well after I've started to AFP and ABF colleagues who are partners of us in this effort. Clearly the Australian Sanctions Office within DFAT is not an investigatory or enforcement body. We are a regulator, and we have regulator functions and regulator powers as opposed to investigation and, essentially enforcement powers. We work closely with all the agencies, and frankly, we work closely with international partners as well on identifying compliance issues. So from a DFAT perspective, clearly, once we have sanctions imposed, there is an obligation to ensure that the regulated community understands the sanctions, that they are listed so that people can find them and undertake due diligence, and that is a DFAT function. So, for example, once the sanctions are applied or individuals are listed under existing sanctions frameworks, we update consolidated lists. We also do an extensive amount of outreach to regulated communities, including the financial sector, to make sure that everyone is alerted to either changes in sanctions frameworks so that we can discuss issues of compliance, issues of due diligence, issues of basically what is covered by the sanctions and not. We have, over the past period of time, issued, for example, I think it's around 7, I know I have the list here, of guidance notes. Some of those came out very specifically after new sanctions were imposed. So, for example, after the first use of cyber sanctions, which was earlier this year, we, together with our DFAT cyber area, produced, for example, an advisory to digital currency exchanges, an advisory, an FAQ on cyber sanctions and ransomware payments, and a guidance note on cyber sanctions. Now, that's part of the DFAT function, and it is part of the compliance function. Doing outreach, providing advisory notes, responding to queries, and we get a lot of queries directly to the Sanctions Office. That is all part of our function. So that's the beginning of the journey. We will, through our partners, we have a number of groupings with overseas partners on which enforcement contravention issues are discussed, and intelligence is provided across particularly the Five Eyes group when sanctions breaches, for example, are detected. So in some senses, we are also effectively a collector. We work with partners overseas, particularly the Five Eyes, but not only the Five Eyes. They will have experience of identifying contraventions that they see in their jurisdictions, and they will pass information to us. They may have information about things that are occurring in our region that we also look into. So in many senses, that is also we are part of information exchanges on circumventions and breaches. We work closely with our partners within the Australian government to monitor, though, as I said, this is a function that we are strengthening now. to monitor things like what assets there might be, what financial transactions there might be within Australia that may be in breach of sanctions. Once we have information, once we identify potential issues, the Sanctions Office may engage directly. It depends on the type of sanctions concern, the type of sanctions breach, or we may refer it directly across to the AFP or the ABF, depending on who is best placed and what the nature of the information is. If I were to give one example, for example, we received information from one of our partners about the use of DPRK IT workers providing services to small businesses around the world. We obtained information that there was something like that happening in Australia, and the Sanctions Office approached the particular small firm who was completely unaware. Now that's, this is part of the Australian Sanctions Office graduated risk-based approach to monitoring and compliance effort. When we have information, and it may come through from different sources, including from partner agencies, we will take a look at it, and we have some powers under the Act to request information. We have a power under the Act to require the production of information that will help us assess whether there has been a breach or not, and we will assess how serious that breach is. In a lot of the cases, there might be inadvertent breaches. Our approach will be one of education and outreach, because what we want is compliance, and we will work with the regulated community. If it is something more serious and it requires investigation, we will pass it to our partner agencies. It depends what it is and how we go about it. So I will actually hand across to AFP and ABF for them to add. But the Sanctions Office has certain abilities and certain powers, but once it gets into harder investigation and certainly into enforcement, that sits with other agencies.
It's Anthony Maguire for the Australian Federal Police, certainly, and we appreciate the comments from our colleagues at DFAT and the Australian Sanctions Office. Yes, we work closely with other agencies in terms of the enforcement of sanctions and also providing information required in order to passing sanctions themselves. Most of our enforcement work actually sits within the EC3 category, which Assistant Commissioner Rice is probably better placed than I am to comment on. But yes, and I'd probably ask Adam if he'd like to add anything further.
Certainly, thanks, Anthony. As put to the committee, when those matters do become overtly criminal in nature and beyond perhaps the expertise of the Department of Foreign Affairs and Trade and the treatment options that are available to the department, that's when those matters are referred to my command. Largely from that point, we conduct reasonably, routine inquiries on those matters. I think we're best placed to fit within the AFP construct as to who will investigate those matters. We conduct an assessment and then refer those matters to the relevant state region of the offending, where the investigation response is best placed to occur from. And then those matters occur really as a routine investigation from AFP's perspective as to what treatment options we may need to put to it in order to bring effect.
How many referrals of possible breaches or identifications of possible breaches have agencies made or discovered? Let's go with since 2022.
If I could, I can probably perhaps comment. I know there are currently 4 active investigations. I don't have.
Sorry. How many?
4.
4. Thank you.
4. One in most, perhaps since the last committee, and I will take on notice though, if I can, to your time frame of 2022 forward as to referrals. I don't have that data with me, and I'm happy to provide that on notice.
Thank you. And of those 4 active investigations, without compromising them, but how did those investigations come to be commenced? Were they referrals from DFAT as a result of their compliance work, referrals from civil society or others who've identified issues, or from AFP's own investigations.
I can perhaps speak specifically to the latest referral. I would find for you again on notice the referral pathway, but I would suggest it is most likely the same as the most recent referral, which is that we work closely with the department. We hold regular meetings with them where we discuss the work that the department is doing and where there may be crossover we need to refer. And where that need to refer occurs, we then work very closely to go, I suppose, the investigation direction and what may be required, and then try and confine the response to something where an outcome can be adequately achieved. And in that last instance, that is what occurred, and the matter was referred to us. And we can take that investigation on. That investigation is currently ongoing. So at most, I would suggest I'll take the further 3 investigations on notice, and I would suggest that they'll be coming directly from the Australian Sanctions Office through that working group pathway.
Thank you. And to the ASO, my understanding is some of your counterparts in other countries do have particular investigatory powers. The ASO does not. How do you see that alignment of powers and its effectiveness in terms of the Australian regime?
That's a very good question, Senator, and I'll come back to that in a minute. Just to note that from our records, I think all 4 of the active cases that the AFP mentioned came from ASO, but we actually have 21 plus compliance matters under review. Now, some of those will be, once we've looked at them, they'll be inadvertent, or we can actually work with those who have breached. Some of them may turn out to be referrals to AFP, but we actually obviously have a lot more matters we look into before we actually refer. Back to your question about powers. I would say we have the Australian Sanctions Office has fairly limited powers in this area under our legislation. I mentioned Section 19, which has the ability for us to require the production of information. There is an injunction power that actually sits with the Attorney General, and otherwise enforcement powers and investigative powers sit with other agencies. There is a legislative review and recommendations that have been made to government and is being considered by government at the moment. I won't go into the details of that. I couldn't comment on whether or not the ASO should have investigative powers or not. We don't currently. It would require a policy decision about whether the Sanctions Office needed additional powers.
Thank you.
I will just, note on that the US has enormous resources dedicated in multiple agencies to sanctions and sanctions enforcement. So there is a difference in scale as well.
Yes, indeed. And I think some of that will come to in the next round of questioning. Can I shift to timeliness of sanctions decisions? And I want to sort of tackle this, if I can, at least looking at a few examples that were given. Cluster of individuals associated with the death of Mahsa Amini of sanctions on Iranians. It took nearly a year after the US had taken action on those individuals for Australia to do likewise. Why the delay in a case like that?
Senator, every country has, as I think you know, different sanctions frameworks, different legislative tests, different legislative thresholds, and each country makes a decision on its own the sanctions was made at the time that it was made. Sanctions are an incredibly important tool that is closely considered whenever one of our partner governments is looking at sanctions. We have close and long discussions with them. We closely coordinate with them. There will be many differences between different countries' regimes. Different countries have different approaches at different times. There will be differences.
Well, I suspect I'm going to get the same answer, but in February this year, again, a welcome series of financial sanctions, travel bans on 55 persons and 37 entities relating to Russia's deportation of Ukrainian children from regions under temporary Russian control. We all agree in terms of the heinous nature of those acts. Those same sanctions in many cases were imposed by the European Union in June last year, the UK in July last year, the US in August last year, Canada in September last year, but not in Australia or by Australia until February last year. I mean, you gave the general answer to the Masa Amini question, but are you able to come to some more specifics about what the barriers or the hurdles are that sees Australia acting so much later than our like-minded partners?
Senator, in my opening statement, I made some comments just about what we do in relation to each consideration of sanctions. I think you've probably heard DFAT officials say many times before you in estimates and the like that sanctions are a tool. They're not the only tool. They're not necessarily the first tool or the most appropriate tool. And every single time we use a sanction, we take into account a wide range of things. I come back to the point that there are differences between countries. If you were to look at, compare all of the different countries that impose sanctions, you'd find a lot of differences in timing across a lot of different things. Every country has to look at its own frameworks, its own legal thresholds, and make its own decisions.
And they are part of the complexities that I do want us to unpack, but it is often, of course, particularly in estimates, we're asking questions about why not or whether someone will. And, of course, those questions always run into the we don't speculate point.
Yes, we don't speculate, Senator.
Indeed. So the reason I'm looking backwards at cases that have been made and decisions that have been made and those examples is because they're not matters of speculation. The Minister has acted upon recommendations to apply sanctions in these various cases. So what is useful to try to then understand and get some detail in unpacking is, and we can take the detailed Russian ones I just gave in relation to those 55 persons and 37 entities. When did Australia start to undertake the assessments on those individuals?
Senator, I don't have that level of detail with me. I would actually have to take that one on notice.
Was it before or after other countries listed?
I would have to take that one on notice as well, Senator.
Well, in general, in cases like this, are we looking at how does it work? Help the committee understand here as to, and I think most fair-minded people would think that Australia, a long way away from a number of these zones and places, is unlikely to be undertaking our own sourced identification first and foremost of we're going after this target or that target. That there will be prompts, and prompts from partner governments, prompts from non-government organisations, and what is helpful is to understand how and when those prompts kick the government and the ASO into action to start a process, and then in terms of your process, how much you're able to leverage the information that partner governments have already got into your assessment so that Canada and Australia aren't just duplicating the same processes and costing each other's countries' taxpayers more cost and delayed time in terms of otherwise coming to timely and effective decisions.
Thank you, Senator. I am actually going to call upon my colleague, who is the Ambassador for Human Rights, who I think can probably talk to you about some of the processes, the internal processes, and how this task is approached for cases that go into the Magnitsky human rights sphere.
Thank you. Thank you, Senator. Yes, if I can just, if it's useful, just outline a little bit more broadly about our approach to human rights concerns.
As long as we come to specifics, because I don't want to keep going back to the broad.
Sure. The point is, though, in our work within DFAT, we work both through the human rights branch and across our other multilateral areas, our bilateral thematic areas, to have human rights issues embedded across all our work. So our human rights advocacy, our upholding and promotion of universal human rights is very much embedded in our work. So when we're looking at issues of concern on the human rights agenda around the world, we work very closely, as I said, with other areas of the department on an ongoing basis about what kind of response we can have. What can we do to try to improve that situation? That is the threshold issues we're in deep ongoing discussion with geographic areas about. As we've explained, obviously there's a range of options that we will consider if we're trying to have some kind of impact and bring influence. And some of those range of many different options that we've talked about, but obviously some of them can be trying to find ways to raise the cost of abusing human rights. And within that, obviously sanctions is one consideration. So broadly speaking, when we are talking with in close consultation with the geographic areas about responding to egregious human rights concerns and abuses, sanctions is always there as part of the discussion from very early on. So then it goes into the consideration, as my colleagues talked about before, about in the particular circumstances with the tools available, taking everything into account, what do we judge at this point in time is going to have the most impact or likely to have the most influence. And that's where those considerations come in. And sometimes over time, the considerations of what might have the most impact and influence will develop and will evolve. But in terms of those, without going into precise details in relation to specific countries, but in terms of those discussions about addressing issues, those are embedded in our consideration of responses. And in parallel to that, we have my colleague has talked about the broader consultations with like-minded countries. We have within that, we also have quite specific consultations on human rights sanctions with like-minded partners on a regular basis, both sort of institutionalised regular meetings as well as ad hoc meetings to keep each other informed about what we're looking at, where the ideas are, where we can share information. So that's embedded in those processes as well, and it's very much something that we prepare for and consider in detail, rather than being, perhaps if you're suggesting some of this is more reactive. Of course, it's reacting to circumstances, but in terms of the planning, the consideration, the coordination with like-minded, it's very much embedded in very regular processes that we have.
Thank you, and appreciate and understand all of that. Perhaps without me asking about a specific, but is the department able to provide a couple of examples or two in terms of stepping the committee through how the engagement and the preparation of the case and the decision for sanctions that have been applied have been undertaken, and where and how that has most effectively engaged with like-minded nations or civil society organisations in most efficiently drawing upon those resources, or indeed, if the current legislation or restraints are creating a burdensome level, then whilst that is the department's job to do so, this is an opportunity to highlight the burdens so that the Parliament and the government are actually thinking about how it could be done better or faster or more efficiently.
We may have to take in the human rights space some notice. I mean, I could invite our cyber ambassador, who is here to talk about cyber sanctions, because those were quite recent, and there are a number of good examples there of just how the collaboration worked. So I'll invite him to talk about cyber sanctions because they were recent and new. And we did some in collaboration with partners. I will actually mention, just from a different perspective, is the Oil Price Cap Coalition. My team will correct me if I'm wrong, if that's what it was called, but just as an example, because it was creative and novel and difficult and continues to be complex. The attempt was to impose a cost on Russia by reducing the price that Russia would get for the oil that it sold. We, of course, have sanctions on direct imports of Russian oil products, but trying to actually impact the benefit to Russia from its oil revenues, whilst not negatively impacting third countries who might maybe relied on it, and without disrupting global energy supply. It was a creative solution at the time. I won't waste your time by going into the detail of quite what it was. It wasn't really a cap. It was basically only allowing people, companies, etc., in our countries to engage with Russian oil exports if the price paid was $60 US, essentially. It was $100 US on other things. So essentially it was to take away the benefit of services like insurance, shipping and the like, if Russia was getting too high a price for its oil. And it certainly had an impact on Russia. It was novel, it was creative, it was difficult. Australia did it at the same time as other partners. And it did actually have an impact on Russia. What we've seen is really sophisticated contravention activity, including through the use of shadow fleet subsequently. But it was a really interesting example where a group of countries came together with a really novel, creative solution designed for a particular impact, and we were part of that. So just as an example, that was actually critical, difficult, timely, and we were able to actually, if not immediately, then shortly afterwards, take it forward. But I have my colleague at the table to give an example of cyber sanctions with others. Thanks.
Thank you. Brendan Dowling, the Ambassador for Cyber Affairs and Critical Technology. I think just to touch on the way we've used cyber sanctions as one of the tools to combat cybercrime, we've done, in every instance we've imposed sanctions against cyber criminals, we've done so in partnership with the US and the UK, and we have imposed sanctions in 3 instances on cyber criminals. They are one tool that we use to disrupt and deter cyber criminals from targeting Australia. We work very closely with our federal police colleagues because they are not the first tool, to the point that has already been made, where there is a law enforcement outcome that can potentially be achieved with actual punitive criminal measures against cyber criminals, and that's obviously a preference to utilise those tools. But sanctions are an effective tool that is used to expose the activities, expose the identity of the cyber criminals, and to disrupt their ability to conduct their operations. They are most effective when done in concert with partners. Cybercrime, I think, as everyone knows, is a global industry, taps into global financial systems, including cryptocurrency mechanisms. So imposing sanctions unilaterally from Australia is not as effective against cyber criminal actors as it is to work in concert with partners. To give an example of how we work in with partners, particularly with the US and the UK, because of the sort of analogies with their regimes to ours. We will, one of us will identify the target in which we're interested in. The first time we used our sanctions was against one of the perpetrators of the Mediabank cyber attack. That was obviously an effort that Australia led, but proposed to our partners that they also look to sanction that same actor and shared the information that it put them in a position to do so. With the other sanctions we've imposed against the Lockbit ransomware group and actors involved in that, and the Evil Corp group, those are areas where we agree amongst the three countries that the prolific nature of those ransomware groups warrants this activity as a means to disrupt them. It is one of the measures, and federal police colleagues will participate in disruption measures that go alongside the sanctions activity. But it is a joint decision that, when the time is right, in concert with the other either law enforcement or technical disruption activities, that sanctions are a measure which are worthwhile to impose against these, and then we look to do it at the same time in concert where we can, to amplify the effect and to really have as much disruption as is possible. And I think experience shows us that the use of the sanctions has been quite a powerful tool against cyber criminal actors, which continues to be a growing scourge affecting not just us but all of our partners around the world.
Thanks, and that was actually a very helpful example in terms of the effectiveness there of cyber cooperation with other nations and coming to the decision-making in that regard. I guess to come back to what led us into that, which were questions more specific to the human rights space, and in terms of those questions around the human rights space, which reflect a lot of the submissions to this inquiry and the evidence we've heard from others. What I'm trying to get some clarity from the department is, in part, a chicken and egg understanding of where cases, individuals identified, let's sort of break it down, in the main, of decisions taken to sanction individuals by Australia for different human rights abuses. Have they been initiated as a result of Australia's own searching out of who those relevant individuals would be, or that sharing of information with other countries, by other countries with Australia?
Thank you, Senator. In terms of a precise breakdown, I'll have to look into that. Some of the human rights sanctions have been, as you know, it's a fairly new mechanism, but they do go back several years, and I'd have to look into the history of each one to get a bit more of a steer of that. But certainly, in my experience, in the last year and a half or so, in all cases where we have where the Foreign Minister has ultimately taken the decision to impose sanctions, the consideration of that and the research behind that has been going on a sort of on a contingency basis, but on a exploratory basis for some time. I can't recall any of those situations in that time frame where that process only started after a like-minded country brought those issues to our attention, particularly because these issues are, particularly when we're talking about egregious human rights abuses, where, of course, monitoring human rights abuses, monitoring and considering, as I said, on an ongoing basis, how we would respond. And the option of sanctions does feature in that very early on in our consideration process. But I'm happy to look and to see if there is more detail and consultation with some of my other colleagues that we might be able to provide on any breakdown on that.
If you could, because I particularly want to drill in there just on the statement you made. You can't recall a time where the initiation of the consideration of sanctions occurred only after a like-minder had brought those breaches and those individuals to the department's attention. Is that really the case? That
I can't recall a time when consideration of sanctions as one of the suite of measures that can be used in response to any egregious human rights abuse is not there as part of the package. That is different from, of course, developing statements of case and moving down the track. But in terms of considering sanctions is always, my point is that when we are looking at human rights, egregious human rights abuses and talking and working with our geographic areas and other areas on how we might respond, sanctions is part of the package of measures that are part of the consideration. How that's taken forward in different cases and different circumstances, and whether we then decide to pursue that further that's a case-by-case basis. But the option of considering sanctions is there whenever we're looking at egregious human rights abuses.
To go back to one of the other examples I gave, Australia didn't conduct its own research to work out who was responsible for the killing of Mahsa Amini, did we?
Do we have?
That was the Mahsa Amini.
Yes, that was countries. Do we have any more information?
Just to confirm, Senator, sometimes the human rights cases are applied under country frameworks as opposed to the Magnitsky frameworks. And Mahsa Amin was under the Iran sanctions framework, and I'm afraid we don't have anyone from the Middle East area here, but we're happy to take that specific case on notice. So that was applied not under Magnitsky but under the Iran sanctions framework.
Sure, but you get the point I'm making.
We do, Senator.
And that point would hold across a whole suite of cases, wouldn't it? Australia is not undertaking own self-initiated investigations into who the Russian perpetrators of horrors are, or the Iranian perpetrators of horrors, or of course other cases where, many other cases where we have made ultimately a decision to apply those sanctions. But quite understandably, and I'm not seeking to make this point as a criticism, quite understandably, we are having those individuals brought to our attention somehow, surely, either by like-mindeds or civil society.
I mean, maybe we will take, Senator, as Ms Mills had said, specific cases that we can potentially come back to you on. If I were to make a general point, of course you are right in that there is a lot of information sharing, not just with other countries, but we are very appreciative of the information that is often supplied to us through civil society organisations, including some of those who've given evidence here. Human Rights Watch and the like will provide information or write reports that will prompt consideration. I mean, this is more something for Ms Mills, but of course there are a lot of different places from which information is obtained, and that may be a starting point, it may be something more, but we will certainly happy to take that question for specific case details back.
You've referenced, obviously, all of our own legal obligations and requirements. Has the department undertaken any assessment of how those legal obligations or requirements could be varied or brought into line of being more consistent with partners like Canada or the EU, such that the sharing of information could enable greater speed to consistent and timely decisions being taken?
Well, Senator, I'll come back to a more generic point. One, as you know, the legislative review has been undertaken with recommendations made. Second, I come back to the point that actually it's not as if there's one common regime that is out there that every other country has and we do not. There are significant differences between every country's regime, actually. And there are differences between every country on many cases when they implement sanctions at different points. Each country makes its own determinations. But we take your point, Senator, as well.
In terms of the legislative review and recommendations made, you're talking about the report that was released in October?
Well, the report was about the legislative review process, and I think that provided some information about where that was up to. The legislative review was undertaken, as you know, the consultation process for the legislative review was undertaken from early 2023. A lot of consultation took place as part of that review. Submissions were received. Those submissions and the submissions actually from this inquiry and from the Russia-Ukraine inquiry, which reported some little time ago, will of course be considered by the department.
So, of those recommendations, are there things that will speed up the department's capacity to be able to take recommendations to the minister and have the minister make decisions that are more in sync with the timeliness of like-mindeds?
Well, Australia will always make its own decisions, of course, as to what sanctions to impose in what time frame, Senator. You know, every case is different.
But when we're coming to essentially the same conclusion, but doing it 12 months later, that is reducing some of the effectiveness of what ultimately is the same conclusion. So how do we get to a point where we're reaching, if it is going to be the same conclusion, that point somewhat sooner?
Well, we will take, Senator, on notice the question that you asked about coming back with cases. The process of reviewing the legislation, the legislative review was completed, the process of changing the legislation continues. And we will take into account the comments that you've made this morning as well.
So are there any changes you can point to that are going to help with that timeliness that we've just been exploring?
As I think outlined in the report, Senator, certain recommendations have been made and that process will continue in terms of legislative reform.
Are there ways that the department has assessed where greater mutual recognition of assessments, information, intelligence may help in compiling the case, not changing ultimately the sovereignty of Australia making our own decision, but being able to more effectively, efficiently and speedily compile the cases?
Well, Senator, we continue to sort of work on our processes to actually streamline all of our processes. And the legislation is under continuous review, our process is under continuous review. I can't answer in any more specific way than that, I'm afraid. I'm not sure if Ms Malls can answer anything from the human rights perspective that would assist.
No, but just to say that the processes for information exchange are quite extensive. So the information and the access to information that we have with like-mindeds is very extensive. And as my colleague has mentioned, we welcome and take very seriously the ad hoc and other submissions that are provided from civil society and other parties. So we do receive and seriously consider a lot of information, have access to a lot of information too with like-mindeds. That's very much a part of the established process.
I know the Chair will want to move the call on shortly, and jump in if it needs to be now, but can I ask, does Australian law permit for assets to be seized and sold and confiscated as part of penalties and sanctions application? And if so, where? If not, is the government contemplating legislative change to enable that?
Senator, I might start and then hand across to my colleague from Attorney General's Department if you're happy with that. Because I can only speak, of course, from the sanctions legislation perspective. Under our sanctions legislation, we do not have the power to seize. We have the power to freeze assets, but not to seize assets. And I think you're aware of that. I would say that this issue of seizure of, particularly of sovereign assets, for example, I'm not aware that any country has actually seized sovereign assets to this point. There is, I know a lot in the media at the moment about what has been done with some Russian sovereign assets in the EU, but it's actually not seizure of the assets. It's utilisation of essentially the interest, the profit being made on those seized assets being utilised. So I'm not actually aware that anyone has seized, pursuant to sanctions anyway, sovereign assets. But in terms of seizure powers, I will actually pass across to Attorney Generals.
Thank you. Thank you, Senator. Nina Harvey from the Attorney General's Department. I probably can't add terribly much to what has already been said, other than to say that any proposal under the sanctions framework or otherwise to seize assets would require legislative change. And perhaps what I could go on to say as well, this is going to give rise to complex legal and policy issues, including complex constitutional law issues. I probably can't go terribly much beyond that without knowing more about the proposals themselves, and it would risk running into the giving of legal advice to the committee.
And just the last part of my question, have departments been asked to look at possible legislative changes to enable instances of seizure to occur, be that seizure of profits, as the department spoke of, or seizure fully of assets?
Well, I would note, Senator, that the recent Senate inquiry into Australian support for Russia-Ukraine actually which I'm looking for currently, made a recommendation in relation to this. And, of course, that report has been made. Government is considering its response.
Sure. But my question, I appreciate government's considering the response. Have agencies been asked to consider any legislative changes or develop options for them?
Well, government is considering the response to the Russia-Ukraine inquiry. DFAT and AGD have been discussing this issue of our powers under the legislation and the freezing of assets, etc. However, I can say no more than that, I'm afraid, Senator.
Sorry, Chair.
Thank you very much, Senator Birmingham. Senator Ciccone, you have the call.
Thanks a lot, Chair, and apologies for the noise in the background. I think my son's just having too much fun at the moment. Look, the Foreign Affairs Minister has said that when Australia applies sanctions, we coordinate with partners because that's what makes them effective. Can I ask, and might be going to the department here, but how does Australia coordinate sanctions with others?
Senator, and I'll ask from I'll answer from the generic perspective, and I'll just check in whether any of my colleagues actually have something that they can add on the specifics. I mentioned in my opening statement, and I think I've mentioned a couple of times, that we coordinate a great deal with partners. I used as an example earlier the oil price cap. My colleague mentioned cyber sanctions, for example. Every sanctions case is different. Every use of sanctions requires complex considerations of impact, unintended consequences and the like. However, there is an awful lot of coordination that happens between countries. There are regular sets of meetings that happen at all different levels of different groupings. Australia participates in a G7 plus grouping, in which we talk about many things, including Russian sanctions, for example, existing sanctions, new sanctions, contraventions of sanctions. How do we enforce the sanctions? How do we make sure they're more effective? And that is continual. There are regular conversations and regular dialogues and a lot of information sharing, intelligence sharing, information sharing about options being considered by others. So the coordination is very, very close and deep. Now, that obviously is particularly so in the case of Russia, given the rapid increase in the number of listings and the number of sanctions that happened after Russia's invasion of Ukraine. Now, I have at the table a colleague from our European division who may be able to give some specifics in relation to coordination on Russian sanctions-related matters, hopefully.
Thank you very much, Senator. Megan Anderson, Department of Foreign Affairs and Trade. As my colleagues have mentioned this morning, it's important to note that sanctions are one of a number and suite of approaches that we have taken, and with our main focus being to try and ensure that there is an impact for Russia for the actions that it has taken and continues to take in Ukraine. So, as noted already, Australia has increased significantly, over 200%. In fact, our actions to ensure sanctions are made against a whole range of Russian individuals and types of entities and people. It's also important to note that it's only one of the suite of actions that is taken, and your question about coordination goes to how we can best have an impact. Is it through sanctions? Is it through the kind of trade bans or trade actions that some of which have been touched on already, bilateral pressure, multilateral pressure, as well as the way that we approach strategic communications, the way that we've approached limitations on travel and those kinds of things. We do have, and I think we've already taken on notice, to come back to the committee with specific examples that may help to step out how we've coordinated on particular actions, how we share information. We do, as my colleague said, work through the G7 Plus mechanism, and we do use whatever way we can through multilateral and bilateral mechanisms to ensure that we're having an impact. It doesn't necessarily always mean the same actions by the same partners. And I think for us that's also, in the Russia case, important to note that different partners may have different leverage. There might be individuals who have more exposure in a particular country than another. So as we work through those cases, important to note as well that the coordination happens. We are looking at each case, but we're also trying to look for those actions that can have most impact from the Australian perspective. Thank you, Senator.
And are there any cases where foreign policy tools might be more appropriate or impactful than imposing sanctions? And I guess, what are some of those tools?
Thanks, Senator. I'd like to take the opportunity, I guess, to touch on recognising this is an inquiry into sanctions, but into how trade measures on both Russia and Belarus complement the type of work that is undertaken with sanctions. For example, Russia has prohibited the import of Russian oil, as we discussed, refined petroleum, coal and gas. We've stopped the import of Russian gold, the export of alumina and bauxite to Russia, the export of certain luxury goods to Russia, the export of machinery and related parts to Russia, and areas of Ukraine that are temporarily under Russian control. Really, our approach here is about using the levers that can stop the benefits to Russia of its invasion, reduce the kinds of finances that could be used or diverted by Russia to support its war effort, and of course stop trade with Russia that might be going towards its illegal invasion of Ukraine. Thanks, Senator.
Thank you. And I'll just touch on briefly also under the broader human rights heading too. Again, we do look very carefully at the full range of measures, and I think we need to, as was just indicated in the Russia context, we're often looking at a combination of different measures and aiming for the combined impact of those measures. But certainly in the human rights area too, there is a lot of other areas which may be assessed to be more effective in some contexts, and a lot of that relates to the bilateral advocacy, the advocacy in country, multilateral advocacy through, for example, statements in the Human Rights Council, statements and resolutions in the Human Rights Council, the Universal Periodic Review process under the Human Rights Council that peer reviews the human rights record of all states globally, can bring pressure to bear. Also, I think broadly, a lot of the work through our development cooperation program goes to issues around, directly or indirectly, around rule of law and good governance. These some of the programs can be, particularly over time, be really important to actually have impact in these areas, and equally work with civil society. And work with local civil society actors who are working sometimes in contexts, fairly quietly behind the scenes, and that's the way they might prefer to work in local contexts, but where we can provide enabling support to their work on, particularly around the defence of human rights. These are all examples of the other kind of tools and approaches we consider.
Well, can I just also turn to another example, but like in a specific bilateral relationship, for example, with China, where we have important consular interests, what are the factors that the government considers in dealing or deciding, I should say, which tools to use?
Senator Daniel Sloper, Head of East Asia Division in DFAT. In each circumstance, we respond to human rights situations of concern by thinking about what would be the most effective way to bring about change. And I think the Ambassador for Human Rights alluded to this before. That will include making representations bilaterally, through multilateral forum, privately and publicly, at a range of levels, including at the highest level of government. It will also give consideration to sanctions and other options. And then thinking about those as a whole, we'll look at what we judge to be most effective in regard to this particular circumstances. So this has meant, with regard to China, on a range of different issues, we've been very clear and consistent about our concerns on specific issues. We have raised them bilaterally, and we do through multilateral processes, including the Universal Periodic Review that the Ambassador outlined, but also through other statements, both in the United Nations General Assembly and Human Rights Council. We express our views. Sometimes we lead those statements, sometimes we join others in doing so. And that is to sustain, if you like, international focus on these issues of concern and highlight the obligations all UN members have in terms of their commitments to sustain and uphold human rights.
In the recent budget, 2024-25, the government provided $26.4 million over 4 years to strengthen the department's monitoring and enforcement of sanctions. How is this investment strengthening the government's ability to enforce sanctions?
Yes, thank you, Senator. As you say, I'm just providing the detail, getting the details now. It was $26.4 million was secured out of the recent budget outcome. The majority of that is coming to DFAT, and it's for additional staffing resources as well as some increased compliance monitoring, sanctions monitoring programs. Some of it provided funding, as I think we've already heard this morning, from ABF and from ABF. It secured some additional resources for ABF, for AUSTRAC and for CDPP as well. What it will enable us to do, or that is the Australian Sanctions Office to do, is basically bolster our regulatory capabilities, to improve monitoring and compliance, to increase our guidance to the regulated community and our outreach to business, and to improve regulated response times and also to mitigate legal risks. Make sure that our sanctions system is operating smoothly and as robustly and, frankly, in as timely a way as we possibly can. We're building specialist knowledge and expertise, including to support and defend greater sanctions compliance and enforcement action. And as I mentioned, we didn't just look at our own resourcing, but at the resourcing that was needed to strengthen our focus on monitoring and compliance across those agencies involved in this process. We have, as I mentioned earlier, what we have seen since the introduction of really quite complex Russian sanctions in 2022 was also sophisticated contravention activity. This requires us not only to work closely with partners across government in Australia, but partners overseas. We have seen a number of those efforts, for example, in relation to the transport of Russian oil and the use of the so-called shadow fleet. So at the moment, we are increasing our engagement, outreach, focus on contravention of the Russian sanctions and what role we can play in that. Since we have started increasing our staffing and increasing our focus on monitoring and compliance, guidance and outreach, we have increased the number of guidance products that we have made available to the regulated community here in Australia on very specific issues that have come up. For example, guidance on digital currencies, for example. I mentioned earlier the cyber-related sanctions guidance notes that have come out. We're increasing our outreach, and we have already been able to take on more assessments of compliance issues. So it will enable us to strengthen our monitoring ability and so that we can actually have a better sense of what is actually happening, what contraventions are taking place, and to inform the activity that we can actually undertake and where we need to prioritise effort.
Well, thank you. And just the last one too, and I understand the government's recently made use for the first time of the cyber sanctioning powers. My question is, did Australia coordinate these cyber sanctions with like-minded countries to enhance their effectiveness?
Senator Brendan Dowling, Ambassador for Cyber Affairs and Critical Technology. Yes, so we've now used the cyber sanctions regime on 3 occasions and have sanctioned a total of 5 cyber criminals. I think the cybercrime is an increasing focus for our government, our law enforcement agencies, as well as our cyber security agencies, because it is a growing scourge. It is targeting Australian companies. It is increasingly targeting the most vulnerable, be it hospitals, childcare centres or schools, and we see that it is an increasing scourge across the region as well. So we're really looking to work in partnership across a range of fronts to disrupt and deter cyber criminal actors. And my AFP colleagues may wish to add to this, but in the global battle against cyber criminals, we act in concert with our partners. It is a transnational crime, so requires a transnational response. What that means in practice is that as we in Foreign Affairs, colleagues in the Federal Police, colleagues in the Cyber Security Centre, look at response options to cyber criminal activity and particularly active cyber criminal groups. There is coordination on sharing of information and intelligence in relation to those activities and what the right response to those activities are. As I mentioned before, that might involve technical disruptions. It might be looking at law enforcement options, ideally if we can achieve punitive criminal penalties against cyber criminal actors. But there will also be a coordinated discussion amongst partners as to whether sanctions are the right tool to use against those particular actors at that time. That decision to utilise sanctions against those actors is taken in concert with partners. It's particularly important to collaborate for a couple of reasons. The first being it exposing the activities of a cyber criminal group and the techniques and tactics that they use. We never wish to cut across the law enforcement activities of another partner. So it sort of has to be a decision that collectively this is the right measure at this right time, so that it's done in a way that doesn't affect other potential levers. But it is crucial that we apply the sanctions in concert. So cyber criminals work within a global ecosystem utilising globally active payments mechanisms, technical computer networks. So to apply in isolation really doesn't have as a powerful effect as it does to apply in concert with partners. So the imposition of sanctions, in cybercrime sanctions, we have done with the US and the UK on the occasions that we've used it. We've also lended our support for the EU's use of sanctions against cyber criminals. We continue to encourage other countries to adopt regimes which allow them to sanction cyber criminals as part of their arsenal to come at this tool. So the idea is that essentially by working in concert with partners, you squeeze the space that cyber criminals have to operate globally. So it is a very closely coordinated affair and will continue to be so.
All right, thanks a lot for that. Thanks, Chair.
Thanks very much, Senator Ciccone. Senator Birmingham, we have about 7 minutes left if you wanted to ask a few more questions until 1 o'clock.
Thanks, Chair. I will just pursue a couple of other lines if I can. Firstly, just to the AFP, just on the actual assessment of Russian entities and assets in Australia. Over the last couple of years, a number of questions on notice have been put by Senator Patterson in relation to your assessments. And in May 2023, AFP responded indicating that there were in excess of 1,800 sanctioned Russian entities and individuals, with 21 possibly the subject of the sanctions regime being identified in Australia in terms of assets or implications there. In October 23, the AFP responded to a similar question indicating there were 23. By June 2024, the response from the AFP was that it has not identified any Australian-based controlled assets. Are you able to explain to the committee the discrepancy, what led you to believe there may have been 21 or 23 assets, and also the degree of confidence you have that there are not any Australian-based controlled assets?
Thank you, Senator. I'm not in a position to answer with the granularity of to answer the discrepancy, but more than pleased to take that on notice and respond in writing, so you've got a fuller explanation to answer your question.
Senator,
okay, thank you.
Senator Birmingham, would I just be able to add in here? I think, as you will know, that Australian sanctions law imposes strict prohibitions on dealing with designated persons or entities and their assets. Asset holders are required by law to provide the AFP with specific information about controlled assets. That's part of the legislation. DFAT works closely with AUSTRAC, actually, in relation to tracking financial transactions. There are frozen financial assets, Russian financial assets in Australia. These may not have been reported to the AFP, which may explain the discrepancy, but we certainly are aware of frozen Russian financial assets in Australia.
What's the scale of the department's awareness?
As in the amount? I think some media has suggested at one point that Australia held 9 billion. We don't hold 9 billion. It is, from the information I have, it's well less than 100 million, and that includes both private and sovereign assets.
And how many individual assets or individual asset holders?
I don't have that level of detail to hand, Senator.
If you could provide that on notice, that would be Helpful, please. To Home Affairs, probably in particular, but again, I'm sure any others will chime in if applicable. Are there any concerns about leakage within the sanctions framework that is enabling companies to import Russian goods into Australia indirectly or by other means?
Senator, as Tony Smith, Assistant Commissioner, Australian Border Force, I think it would be fair to say that there are no immediate concerns that are raised specific to the point that you've just raised in this inquiry. Naturally, from a border perspective, we acknowledge the fact that leakage does occur when we have 95 million cargo consignments that move across the border. We target our efforts based on information and intelligence to ensure that we are targeting the goods of suspect concern as best we possibly can. But to acknowledge the fact that leakage does occur, but our role at the border is to ensure that that leakage is minimised to the highest level possible. But just to reiterate, there's nothing in relation to what you've just raised as a matter of concern that I'm aware of.
What instances of potential breaches have ABF identified or investigated under the Russian sanctions?
Specific to Russian sanctions, I can't comment on that at the moment. I would say that from a referral perspective, since July 2024, we're managing 6 referrals from the ASO and have 5 active investigations that are underway at the moment. I can't comment on specific details in relation to those investigations, but I will call on my colleague, Superintendent James Ryan, just to see if there's any further information.
Thank you for that, Senator. James Ryan, Superintendent, Counter-Proliferation. So in relation to those 5 active investigations, I can confirm that 2 do relate to goods suspected of being exported to Russia. However, further comment, I guess, at this point in time would not be appropriate. And I guess in relation to our risk approach, as colleagues have said throughout the day, we work collaboratively with partners both here in Australia and internationally to ensure that our border mechanisms are appropriate to the commodities subject to sanction, and to ensure that our profiles are appropriately risk-based to identify and stop those.
So 5 breaches of potential sanctions, 2 of those 5 relating to potential illegal exports of goods to Russia. Are you able to categorise the other 3 at all?
In relation to our investigations, Senators, they would be violations of the Customs Act. And in relation to these particular investigations, they would be either import or export sanctioned goods. Further comment at this time wouldn't be appropriate.
Okay, thank you. See you there, Chair. Thank you.
Thanks very much, Senator Birmingham, and thank you to the officials for appearing as witnesses today. The due date for questions on notice is Monday, the 2nd of December 2024, and the committee will now break for lunch and resume at 1:45. Thank you all. now recommence our hearing, and I welcome representatives from the Myanmar Campaign Network and the Australia-Tibet Council. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your name and the capacity in which you appear today? And we'll start with the Myanmar Campaign Network.
Hi there, thank you. This is Tasneem Rock. I'm the campaign manager for Myanmar Campaign Network. And I'll pass.
Thanks, Ms. Rock.
Thank you. I'll pass to Professor Tway Tway as well, who's also representing Myanmar Campaign Network.
You might be on mute.
Hello?
We can hear you now.
Can you see me as well?
We can't see. Oh, yes, we can. Oh, good.
Oh, good. Hello, hi. My name is Tway Tway Thane. I'm an associate professor at Curtin University from Perth, Western Australia. I'm joining as a member of Myanmar Campaign Network. Thank you very much.
Thank you very much. And representatives from the Australia-Tibet Council?
I'm Dr. Zoe Bedford. I'm the Executive Officer of the Australia-Tibet Council.
Thank you.
Good afternoon. My name is Sonam Gyaltsen. I'm the digital campaigner for the Australia-Tibet Council.
Thank you very much. I now invite you to make a short opening statement, and at the conclusion of your comments, I'll ask senators to ask questions. And we'll start with the Myanmar Campaign Network.
Sure, thanks so much. So I'm dialing in for the land, from the land of the Bedigal people of the Eora Nation. Myanmar Campaign Network is grateful for the opportunity to participate in this public hearing. We're very pleased to appear on this panel with Australia-Tibet Council and fully support ATC's submission. Both Myanmar and Tibet provide case studies to inform the committee's inquiry. In addition to the practical recommendations we've given in our submission regarding Australia's sanctions regime, we wish to again highlight our concern over the limited Australian sanctions that have been issued on Myanmar, and that the Magnitsky amendments have not been utilised to address the crisis, which worsens every day. The brutality and frequency of junta attacks on civilians has increased in the past 6 months, and it's a crisis that not only affects the people of Myanmar, but regional stability and Australian national security. The transnational crime that has proliferated in this chaos directly impacts Australians through scams, drugs and illegal goods. We have advocated for sanctions on high-value targets such as state-owned enterprises that fund the junta and the aviation fuel supply chain, but believe that this is a matter of such urgency that we're now calling for sanctions on the Central Bank of Myanmar, which is the key financier of the Myanmar junta and enables sanctions evasions and supports corrupt economic networks. I'll just pass to Professor Tway Tway to take that last little segment of our opening statement.
Thank you. Thank you. So I'll answer the question of what's in it for Australia in terms of taking a leadership and resolving Myanmar crisis. So it's a geopolitics at stake here. So China's influence in Myanmar, of course, is growing and growing since the coup happened, and Myanmar is falling into debt more and more into China. And China has a big interest, strategic interest, economic interest in Myanmar. So I want to focus on this deep sea port, dual deep sea port that Chinese and the junta are building. So that is dual, as in can Chinese, if allowed by the Myanmar government, can launch their navies into Indian Ocean. So the security in the Indian Ocean, Chinese Navy's access to Indian Ocean is of very, very important to Myanmar, to the Chinese government. So solving Myanmar crisis, bringing democracy back to Myanmar, will lessen the Chinese influence in Myanmar, and also this security issue. Focusing in the Indian Ocean will be more secure and lessen. It's a direct interest to a democracy like in Australia. And why Australia should take a really leadership role, not working behind the ASEAN. ASEAN has been ineffective. Everyone knows it. Everyone knows it. They also sometimes admit it. So Australia, as a democracy with democratic value, should not work behind ASEAN, should take a leadership in promoting democratic values in ASEAN. So we want to call for a sanction on central bank, because central bank is where it's still funding the only advantage the junta has right now, which is the aviation power. Buy arms, jet fighters from Russia, China, to attack the civilians. So to cut off this hard currency access, sanctioning central bank is ultimate goal should be. And Myanmar people go hooray every time sanctions is supported. They want sanctions because life could not be harder under the regime. And sanction or not, the lives is getting harder and harder. So they really want this crisis to solve. And democracy like Australia in the region really look upon, to take this role. Thank you.
Thank you very much for that. And Australia Tibet Council, your opening statement.
Good afternoon. And Australia Tibet Council also welcomes the opportunity to make a submission and to speak to this inquiry. Australia is yet to impose any Magnitsky sanctions on any Chinese Communist Party officials for human rights violations in Tibet, but also not for violations against Uyghurs, Hong Kongers, or any Chinese democracy activists. Whereas the USA sanctioned several CCP officials, they're listed in our submission, for human rights abuses specifically against Tibetans and Uyghurs. And their human rights violations in Tibet include extrajudicial killings, physical abuse, arbitrary arrest, mass detentions in Tibet, as well as forced sterilisation, coerced abortion, restrictions on religious and political freedoms, and torture of prisoners. And these are grievous human rights abuses, and we are afraid that the Australian government is allowing the Chinese government to commit these crimes with impunity by failing to impose any Magnitsky sanctions on individuals. The USA has also issued visa bans for CCP officials in relating to the Chinese government-run colonial boarding school system, which is a system that has resulted in the separation of up to 1 million Tibetan children from their families into Chinese state-run institutions. The banned officials are responsible for this policy of forced assimilation that is designed to eliminate Tibetans' distinct linguistic, cultural, religious traditions in children as young as 4 years old up to 18 years old. Foreign Minister Penny Wong has applied Magnitsky sanctions to 13 individuals and 3 entities from Russia and Iran, and yet none to CCP officials responsible for widely recognised human rights abuses in Tibet, Hong Kong, East Turkestan, which is the home of Uyghurs. The inconsistency of Magnitsky sanctions is a great concern to us at the Australia Tibet Council. Magnitsky sanctions are, of course, designed to target individuals accused of gross human rights abuses by means of assets freezes and travel bans. And currently the CCP can arrest and torture Tibetans with impunity from Australia. Magnitsky-style sanctions on CCP officials are one of the few tools that Australia has that could deter officials from their brutality towards Tibetans and punish their abuses of Tibetan human rights abuses. So it's something that we feel strongly about because it's something that could create a behaviour change in Tibet. And there are very few mechanisms for creating that. Currently, Tibetan community members who are trying to go back to Tibet to visit family, even under the lifting of any kind of visa restriction, 15-day visas in China, are finding that they're being detained when they return, sometimes for several hours, sometimes for almost a whole day. They're being questioned by police. Families are, including children, and then sometimes they are then forced to return to Australia, and they're not allowed to travel on into China. Of course, they're not allowed to travel to Tibet because going to the Tibet Autonomous Region, what China calls the Tibet Autonomous Region, requires a special permit, and Australian Tibetans have not been able to access that. And, in the USA, they have reciprocal access bill, which allows for sanctioning individuals who are denying visas to people who wish to travel to Tibet as part of their trying to ease these restrictions. So we believe that Australia should join our allies in sanctioning CCP officials responsible for human rights violations in Tibet, and that in Australia, the Magnitsky Act has been underutilised by the Australian government as a mechanism to improve the lives of Tibetans in Tibet. And given the seriousness of human rights abuses in Tibet and the threats of cultural genocide, it's time for Australia to take action in this way of Magnitsky sanctions. Thank you.
Thank you very much for that, Dr. Bedford. Senator Birmingham, you have the call.
Thanks, Chair, and thank you all for your submissions, participation, and opening statements. Obviously, we all recognise the great trauma faced by the people of Myanmar in what has been a very long period of trauma and tragedy for them, and of course the enormous challenges that Tibetans face. Including the oppression of culture and difficulties that presents for all in those circumstances, and the advocacy that your groups provide, even though it may not always be acted upon, is really very valuable for our public debate. I want to just deal with one specific point made by the Myanmar Campaign Network around particular moment-in-time opportunities for sanctions, but then come back to some of the broader issues before the committee to both parties. And that specific point was the reference to the aviation powers and capabilities of the junta at present, and the possibility of being able to more effectively curtail those, and in doing so, remove effectively the one significant power that the military currently has. I'm just wondering if you might elaborate a little on the assessment of the situation on the ground in Myanmar and the abuses that are occurring through the use of that aviation power, and then the type of sanctions and actions that you think could and should be taken to remove that capability from the Myanmar military.
Sure. Thanks very much, Senator. Professor, I might start off, and then I know that you have a lot to say about this, so I'll pass on to you as well. So the main issue is that the Myanmar military do not, Myanmar doesn't manufacture jet planes, helicopters, drones, and it doesn't manufacture aviation fuel. So it requires foreign revenue to purchase these items from elsewhere, oftentimes China, Russia. Amnesty International did some excellent investigations into the jet fuel supply chain, and they've created a pretty much a dossier of the supply chain. And based on that, Australia has issued sanctions, as has the international community, but those sanctions have been evaded. So we're finding that aviation fuel is still finding its way into Myanmar. And Professor Tway Tway, maybe you'd like to talk about that, because I know that's something that you're quite passionate about.
Yes. So this sanction evasion is happening. So they are scrambling for hard currency. So the sanctions is to do with hard currencies. I'll talk next. But this, so they can go to China, India, and other suppliers. So we have two prominent suppliers being sanctioned. But there are other suppliers that they can't just, not suppliers, distributors in the country, which have access to hard currency to buy fuel overseas. So you just are kind of, whack-a-mole, you just kind of switch. But what you cannot switch here is juntas access to hard currency. So oil money they can have, but they all has to come from offshore. So sanctioning this Myanmar Central Bank, which is the conduit to get this hard currency, will be very, very effective. But all governments are very reluctant to sanction central banks. That's a common trend all over the world because of the fear that they might also impact ordinary citizens. But in Myanmar case is different. Ordinary citizens don't have access to hard currency. Whatever hard currency they have in these state banks, regime has got control of it. 30%, 40%, 45%, they've taken it and converted into whatever they want to use. So, this sort of banks and hard currency are not everyday lives of Myanmar people, trust me. So, sanctioning central bank will be highly effective, and Australia should make up for the being behind in sanctioning and sanction central bank. That will really tackle the core of the problem. The only advantage the regime has right now is air power. Air power means, their financial ability to buy jet fighters, all that from Russia, and also jet fuels. It's about 60 attacks a week or something happening. And it is horrific. That's the only advantage it has is air power. And we can stop that by financial sanctions, and the one to sanction is central bank, which we haven't. Thank you.
If I could just add to that as well, yes, absolutely supporting what Professor Tway has said. And in our opening statement, we feel that this situation is so terrible that we have to effectively shut down the entire financial system. In relation specifically to what you've asked in regards to aviation fuel, in that case, we would recommend looking at Magnitsky-style sanctions because they are thematic, they're not just country-specific. And as the Amnesty International report has shown, there's a wide range of suppliers internationally, and that would be our recommendation. But yes, as Professor Tway says, we need to cut the cash and we need to sanction high-value targets such as the Central Bank of Myanmar. Thank you.
And regime is increasingly losing towns and regions as well. So according to latest statistics, was it 75% is now occupied by the opposition. So all they have is in the lowlands, the capital and the commercial capital. And so the opposition forces are going in regardless of Chinese support or what they determined. And the regime is losing ground, and they're fighting back with increased air power indiscriminately.
Thank you, and that's why I described it as in this case, an element of moment in time as well, that the regime having lost so much ground and increasingly desperate in its use of those types of airstrikes, as horrific and indiscriminate as they may be, trying to find ways to curtail that. I appreciate the arguments made on the financial side, understand that trying to get a comprehensive agreement around air power is difficult, but it is, given the horrific way in which it is being used, one where, frankly, it shouldn't just be the liberal democracies or others looking at how they might respond to that and curtail it, but actually other countries, including China themselves, potentially. But to some of the broader issues, firstly, just in terms of comparisons, can I ask each of you how you would describe Australia's extent of sanctions applied in cases of Tibet and Myanmar relative to those of our traditional like-minded and partners such as Canada or the UK or others you may wish to cite, and the degree of disparity that exists in these cases?
Were you directing that at Myanmar Campaign Network or at Australia Tibet Council?
No, each, please.
Okay. Well, we've had the opportunity to speak. Australia Tibet Council, you take it away and we'll follow up.
Okay. Well, I think that the situation for our two organisations is a little different in that, as I said before, Australia hasn't applied Magnitsky sanctions to CCP officials, whereas as you say, other countries have, certainly the US has, and the UK has, and there, we think then, to point out that we think there's a large scope for harmonisation, and that these sanctions are more effective when they're applied across the board. And then you don't run the risk of, one country being like a safe haven for human rights abusers to invest their money or have a lot of contact with, whereas others are closed doors, So the harmonisation between our allies, obviously we have allies in the Quad, the Five Eyes, AUKUS, etc., and certainly other regional forums where we could have allyship and harmonisation of Magnitsky sanctions when applied to China. Particularly for Tibet, obviously, is our concern, but other human rights abuses in China also, yeah.
Thanks very much. I think that we can typify Australia's response in terms of sanctions on Myanmar as what's the right, ponderous? Professor Tuetue, what would you? And it's not to say that the sanctions that have been issued are not important. They are extremely important. But what we're seeing is sanctions are being issued once a year on the anniversary of the coup, while every day this death toll gets higher and higher. Sorry, I'll let you also speak, Professor Tuetue. This contrasts quite sharply with the action that has been taken by the US, UK, EU, and Canada. They are, in fact, coordinating together on certain sanctions. We know that Australia, the Australian Sanctions Office, is in regular communication with those other sanctions officers, and the Australian, the Australian Sanctions Office and DFAT has shown that they can act swiftly in coordination in the case of Russia. What we're seeing here is it's too little too late. That's the way I would say it. Professor Tuetue, do you have a comment?
Yes. Just to add, Australia's sanctions on Myanmar are glaringly lacking and behind, really trailing behind our like-minded other democracies like UK, US, Canada, the EU. So I think right from the beginning, of course, we had this, challenge with Professor Sean Turnell being in prison. The imprisonments of him, of course, complicated, our Canberra's decision what to do. But then there's other views is that not because of Professor Sean, in spite of Professor Sean as well, because Sean has been out now and the sanctions are also only a little bit here, but too slow and, this is too late. So what happened is right from the beginning, I think the Australian government has taken the ASEAN line, unfortunately, ASEAN, because ASEAN countries don't have the tradition of sanctioning. So, of course, Australia being in the region, understandably, follow the Australians' line and a non-sanctions approach. But then the question is, while sanction is one of the tools, other tools, have they worked? No, they haven't worked. And now Myanmar, 2 million people are at the risk of starvation within months. The Guardian article has reduced, and UN has said it as well. So it is quite a serious time, to take interest in this forgotten land. Thanks.
Thank you all. In referencing Sean Turnell, you've highlighted part of the challenge that Australian governments face in terms of how they balance the equities that exist, be they economic considerations, trade, engagement, or, of course, sensitive consular cases, security issues, or the like. How, as organisations passionately campaigning over the human rights issues facing the people of Myanmar, Tibetan people. How do you believe government of the day and our sanctions legislation should give weight to those other equities and interests of Australia overall?
I'll speak to that. It's a real shame to feel that that human rights concerns are put in any way on a back burner over trade relations with China. China is, of course, a very strong trading partner, but Australia's in quite a unique position where we're not in any kind of trade deficit to China. In that case, we feel that Australia can be a strong voice, for human rights, whereas some other countries that are in deficit to China are very weak, in calling out their human rights abuses. But Australia has the ability, we believe, to remain strong on human rights, and we've shown over the recent years that China needs us in trade, as much or more than we need China in trade, and that's another reason why Australia should remain firm on human rights in this area. We've got in our submission that, the former process of the Australia-China bilateral human rights dialogue is now finished and defunct, and we want to point out that we don't want to see a return to that because it was an ineffectual process that produced no results and certainly had no transparency. But since it has finished, there's no new process for how to sort of have a standard and regular engagement with China in human rights. Of course, we get some assurances from the Foreign Minister's Office that they raise human rights when they speak to China, and there's been human rights abuses in Tibet raised by Australia at UN level as well. But we think that there should be a strong, mechanism, an annual mechanism, a hearing in place that could involve Tibetan communities, Australia Tibet Council, and also Uyghurs, Hong Kongers, Taiwanese, Chinese democracy activists, etc. And from that, there could be some recommendations or targets around sanctions, including Magnitsky sanctions and other things, to make sure that we are actually progressing and improving human rights abuses in Tibet instead of just, mentioning them to China only to be ignored by them and then to continue on straight away with trade negotiations. So, in answer, we feel that at the moment there's an imbalance and there's far more weight on trade relationships with China than there are on addressing these important human rights concerns. And I'll hand over to the Burma campaign.
Yeah, if we have the opportunity, I would second what Zoe has said. Obviously, and Professor Twai, I think that you should talk to this, but China has such a huge interest in Myanmar. And, we obviously, since 2020, we've been trying to, Australia has been trying to sort of regain some of the sanctions and tariffs that have been placed on Australian goods. Is it possible that, that priority has been placed on trade and they have, the Australian government has, eschewed its human rights responsibilities in regards to Myanmar. Actually, Professor Twai, I'll let you talk to that.
Yes, so 10 Australian companies are still operating in Myanmar unhindered because mining sector is particularly opaque and it is non-transparent, and the juntas' hands are everywhere. So the fact that the 10 Australian mining companies allowed to operate, it really risks this reputational risk, for Australia. Because, Australian companies, wherever we go, from beef to, water to mining, we sell on this clean image, right? Respect for business and human rights, OECD guidelines, adherence to it. So them being allowed to run amok, operation as business as usual, unimpeded, is quite astounding. And we made a submission and all that. There's a big report by a reputable, very international journalist companies, and then there's no action. And also, in terms of sanction evasion, some Australian, the Myanmar individuals, either living here or studying here with full visa, and they have this, financial access to help the junta to get around sanctions. And really, these individual, visas of the junta family and cronies, their affiliates, should be really looked into if there is a political will. Thank you.
Thank you. And related, flowing on from that, and an inquiry that is clearly looking at the nature of how we might strengthen our sanctions regime. And given the varying degrees of acknowledgement about how governments try to balance those weights of national interest in the arguments you're putting, how do you think, and what changes in particular do you think to the sanctions regime could most enable governments to better balance those equities, in your opinion? And what role might a tighter or more coordinated approach with like-mindeds have in trying to achieve a more effective balancing of those equities, in your opinion?
Well, I think I can answer in brief. At the moment, we think a harmonisation approach is a good approach and should be used. And as we pointed out before, currently Australia is lagging behind some like-minded countries in terms of applying sanctions to CCP officials. And also, just to the point, I mean, we're actually just asking for the current Magnitsky sanction laws to be applied to CCP officials because they haven't been yet. And so a huge improvement would be just using the laws we have currently on CCP officials, and it's just I think we've made it clear in our statement. It's quite challenging for us to understand why they haven't been applied to CCP officials when the breadth of human rights abuses in Tibet and other areas in China is so vast, and so ongoing. So. In that we just actually at the moment would like to have the current laws applied because they haven't been, and that's where we're really falling behind. Australia's really falling behind at the moment. Yeah, so
Yes, I also like to quote what Zoe said about use the law we have. So we have it and we use it.
Wonderful. We're at time for this session, but I'd like to thank the witnesses for appearing today. And the committee would appreciate responses to questions on notice to be provided by Monday, the 2nd of December 2024. I'd ask that you now disconnect from the video conference, but if you wish to continue to observe the hearing, you can do so on the PollView website. And I now welcome representatives from the Uniting Church in Australia, Dr. Mark Zernsak and Mr. Clancy Moore from Transparency International Australia. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you please state your full name and the capacity in which you appear today? And I'll just get my video conferencing working. Mr. Moore, might start with you.
Thank you, Senator. My name is Clancy Moore and I'm the Chief Executive Officer of Transparency International Australia.
Thank you very much. And Dr. Zernsak?
Dr. Mark Zernsak, I'm the Senior Social Justice Advocate for the Uniting Church for the Synod of Victoria and Tasmania.
Wonderful. I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions, and we'll start with Dr. Zernsak.
Thank you for the opportunity to appear before the committee. As you heard just from the previous witnesses, we probably take the view that the Australian government has been relatively slow at following its allies at times in applying sanctions to similar targets. Our submission goes to the need for greater sanctions against people who have been involved in grand corruption, so expanding in that space. And then we also did suggest a number of areas where we think there need to be further complementary reforms to make sanctions more effective. So one of the big issues, of course, is entities actually knowing that once a body is sanctioned, that they should apply those sanctions. I think it was fairly alarming to me that there was a Law Council report put out relatively recently that actually showed a lot of lawyers don't do any sort of basic due diligence checking of their clients. And even if they did, one of the easy ways to obviously beat a sanctions list is for the sanctioned person or entity to use a nominee. And in the absence of nominees having to disclose who they're acting for, that can obviously make the task of bodies in Australia upholding the sanctions regime more difficult. In addition, we do think there is a need for further reform around unexplained wealth orders, and illicit enrichment would be spaces to play in. And finally, the development of a beneficial ownership register and a law that would require, as I said, nominees to disclose who they're actually acting for. Thank you very much.
Thank you, Dr. Zernsak. Mr. Moore, an opening statement from you.
Great. Thank you, Senator, and thank you for the opportunity to speak today. Look, as an anti-corruption organisation, we strongly believe that sanctions can be a much more effective anti-corruption tool, particularly to counter kleptocracy and also grand corruption, and particularly even more so when the proceeds of crime and corruption, including from such countries as Myanmar, Iran and Cambodia, often fund other criminal activities and also human rights abuses as well. What we're really looking for is the approach for Australia's corruption sanctions to align much more closely with our anti-money laundering and counter-terrorism financing regime. However, and this is important, for this approach to be effective, we would recommend a dedicated independent task force that could coordinate law enforcement across government and provide a formal link between the imposition of sanctions and the opening of other corruption investigations as well. I think it's just important to note that since the original anti-corruption designations in March 2022, when Australia introduced 14 designations, including on individuals involved in Magnitsky's maltreatment, Australia has not made any further designations under our thematic anti-corruption sanctions in comparison to 100 human rights designations in that same time. Just to compare different allies and noting different regimes and different institutional capacities, but the US, as of December 2023, had designated 316 individuals or entities under their corruption sanctions, and the UK, as of April 2024, had designated 42 individuals as part of its global anti-corruption sanctions regime. So in terms of the main recommendations that we put forward, Senator, firstly, the government should create an independent advisory body to receive nominations for sanction targets, consider them, and then make recommendations for the minister as ultimate decision maker. And I would note that this was a previous recommendation of the Joint Standing Committee on Foreign Affairs and Trade, Defence, Human Rights Subcommittee. Also, when civil society NGOs provide information or sanctions designations directly to the Australian Sanctions Office, the office should develop a clear path and process, including timelines and receipt of information, and also data security precautions. Often there's very high-risk data being shared with the Australian Sanctions Office as well. Where assets have been frozen, we would encourage law enforcement to increase the transparency and reporting of such assets being frozen, which would help build trust in Australia's sanctions regime. Similarly, where there are examples of grand corruption, as my colleague Dr. Zernsak touched on previously, where money is stolen from communities overseas, Australia should look to create an asset return or reallocation program to return assets to those communities that have had them stolen. And lastly, and by no means least, to really increase the effectiveness of Australia's sanctions regime, Australia needs to do much more to focus on the enablers of sanctions avoidance and circumvention. This includes professions like lawyers, accountants, and banks. Thank you for your time.
Thank you very much, Mr. Moore. Senator Birmingham, you have the call.
Thank you, Chair. Thank you all for your submissions and participation today, and in particular, Transparency International. Thank you for your very detailed submission and extensive specific recommendations posted in that submission. I'd like to explore a little in terms of your engagement with the Australian Sanctions Office and advocacy for particular sanctions to be considered
in different instances. That, as you've identified, very limited use of the powers established in relation to corruption and limited relative to other nations. So, what type of advocacy has Transparency International made to the government and to the ASO in particular? And could you talk us through perhaps a little bit the nature of that and the type of responses you get in return?
Thank you, Senator. Firstly, I would commend the openness from the Department of Foreign Affairs and Trade and the Australian Sanctions Office in actually engaging in advocacy and conversations with civil society. We've provided advice and recommendations to improve the effectiveness of Australia's sanctions regime, including the transparency of reporting as well. On individual matters, including one case involving an Australian mining company that was operating in Russia, we provided some direct correspondence to help illuminate issues around what we would have argued, or what we argued was sanctions avoidance, alleged sanctions avoidance by that particular entity that was in fact mining and exporting coal in Russia, despite the fact that Australia had designated Russian coal as a sanctioned good. This led to the further enrichment of the Putin regime, and obviously was an alarm bell for us, and we were seriously concerned with the matter. I would also note that the ASO has been provided with a recent budget increase of around $26.4 million to strengthen its investigative powers and functions, and I would encourage the government to continue that funding commitment so that the ASO can do proper follow-up and potentially, limit the avoidance of any future sanctions designations.
Thank you. Just to drill down to actual advocacy around listings and that engagement process. Has Transparency International Australia made specific advocacy on potential new listings, replicating some of those examples you have given from other jurisdictions?
We are often in the position of providing information to the Australian Sanctions Office. I obviously won't go into specific details. I think one of the concerns, Senator, is a lack of response from the Australian Sanctions Office to our information that's provided. And I think the recommendation put forward to have some clearer timelines and processes where civil society groups or diaspora groups provide that information would help build trust between stakeholders and ultimately, hopefully improve the effectiveness of the regime. I would note that we do have a quarterly or every sort of 6 months sit down with the ASO, which is a highly valued platform. But I would encourage the Australian Sanctions Office to maybe broaden the group of stakeholders that participate in that roundtable dialogue, and for further kind of timelines and sort of receipt of information requests, as I outlined in our recommendations.
Thanks. And you've referenced the additional resources, but also in drawing the comparison with other countries and the number of decisions made by other countries. Now, the tension point there exists in terms of, as the department explains to this committee, Australia's own laws, the difference in those laws, the need to be able to undertake and defend, of course, a robust assessment against those laws. How do you think there is possibility to find ways where the assessment and information and intelligence of other jurisdictions can be mutually recognised in a more coordinated manner, that without undermining the ability of our government to be the ultimate arbiter and determinant of whether or not a sanction is applied, could speed the process up and also reduce the extent of resource requirements to be able to cover the field as broadly as so many organisations would encourage the Australian government to do?
Absolutely, Senator. I mean, I would note the differences in legislation, particularly in the US and Australia's sanctions regime, but we know that Five Eye partners are coordinating on a bunch of national security issues, including sanctions. And I would encourage any sort of more formalisation of mechanisms around evidence briefs, assessments of intelligence to be invested in and operationalised if they're not already, because it would ideally make the system more efficient but more effective if there's a coordination between allies. And what's also demonstrated through the evidence is if there isn't coordination in the designations of corrupt actors or human rights abuses, sanctions aren't as effective. So I think it's an efficiency argument and an effectiveness argument around greater coordination and sort of harmonisation and partnership with our allies.
Yeah, the first.
Can I just add? Oh.
Yes, please.
So I was just going to add to that. I mean, I think what was interesting is when you look at Australia's response to sanctioning Russian individuals and entities following the war in Ukraine. I mean, the Australian Sanctions Office was able to move very quickly in that space by comparison to other areas such as Myanmar. So it does show when there is a sort of political will and an interest that there is an ability to apply sanctions in coordination with allies far more quickly.
Thank you, and understand that point. The first of Transparency International's recommendations is to establish an independent advisory body, and then subsequent recommendations hang off of that in terms of some of the process and transparency considerations that such an independent body could entail. Looking at other jurisdictions, what do you see as best practice at present in relation to that type of independence and how it guides decision making? And is there a model or the best parts of other models that you think should form part of how Australia approaches this?
Mr. Moore, I think you might be on mute.
Sorry about that. I would note that it was a previous recommendation in the committee's report before the Magnitsky legislation was legislated for in 2022, but I'll take that question on notice and provide more information as to the preferred model about how that would work.
Okay, thank you. And in particular there, as to models that you can see from overseas as to what might be able to be applied in that regard. Last area that I want to explore with these witnesses, Chair, is on the topic of confiscation then, and how you believe we can move from a freeze to a potential seize framework for instances of significant abuse, and how that can occur in ways that may be analogous to aspects of domestic criminal victims of crime approaches, or what other similarities you could draw, please.
I'll jump in quickly on this. I mean, I think there are two different aspects to this that certainly we tried to pick up in our submission. So one would obviously be where an entity or an individual has been sanctioned. I mean, the dispute then on terms of moving to freezing and seizing would be proof of ownership of the asset. So if the individual or entity owning the asset is sanctioned, it's a matter of if the asset is then seized, for them to actually have to, or for for proof of ownership to show that it wasn't the sanctioned entity or individual who owned that asset. I think the second aspect we were drilling down on was where there is an individual who has shifted assets into Australia, who may be involved in corruption, having mechanisms that actually would allow for the seizure of those assets and potentially, as Clancy raised, return of those assets where the individual hasn't been able to prove that they had a legitimate income source to justify why they are in possession of that asset that they've shifted into Australia.
Just to add to Dr. Zernzak's response, Senator, currently if there's a corruption designation, there's no formal mechanism between law enforcement to commence an investigation. So I think if that formal investigation was legislated for or part of the regulations, you'd get a much more seamless approach to assets being freezed and then time for follow-up investigations by the AFP or other law enforcement agencies. So that's one of our sort of key recommendations that we put forward. And I think there's a similar model in Switzerland that I can share more information with the committee at a later date on as well.
Thank you, much appreciated. Chair, that'll do me.
I'm just checking whether any other committee members have questions for these witnesses.
Claire, I've just got maybe just two quick ones.
Thanks, Senator Shikombi.
I think the page 5 of your submission talk about the need for better communication of sanctions to Australian businesses likely to come into contact with sanctioned individuals and entities. How might this communication be improved?
I think I think one of the things that we are seeing is the anti-money laundering bill that's currently before the Parliament, where you would require facilitators of cross-border transfers to actually have to do some level of due diligence. And as I mentioned before, there was a Law Council report showing very low levels of due diligence being conducted by lawyers, for example. And our experience with real estate professionals would be fairly similar, where we suspect there's not a lot of due diligence being done. So where there are high-risk facilitators, having an obligation to check would certainly be far more helpful, but then also improving the tools that would allow people to check as well and making that task easier. So as we outlined, particularly addressing that issue of nominees, because if I go to the sanctions list and I search, well, I might find the sanctioned individual only if they've actually used one of their names or one of their known aliases. But if they've managed to put up a relative or a minion or a nominee, then that task is going to get much harder. So the easier we can make it for those who are checking to actually identify whether they're dealing with a sanctioned individual or someone acting on their behalf, the better that would be. But look, it's always going to be quite a challenge in this space around that, because and I probably would stress here, at least the more we make it more difficult for sanctioned entities and people to actually shift assets easily, and the more effort they're going to have to put to do that, the less likely Australia becomes as a jurisdiction that they'll try and shift assets into.
Is there any best practice or other examples from other overseas jurisdictions that you've seen too that you think we could look at? Look,
I certainly think one of the things the US does really well is actually publicise where assets are in a way that I don't think the Australian Sanctions Regime, Australian Sanctions Office has done. So you'll get regular press releases about assets that have actually been identified, freezed, seized in those spaces, and that's communicated quite well and easy to find. And I think that my sense in the US is that's built a much greater awareness among entities about the need to check the sanctions regime, be more aware of it, and also that there is a law enforcement effort being undertaken to actually make those sanctions effective. I think part of motivating entities to check the sanctions list is having them understand that there might be follow-up from Australian law enforcement if they're not actually checking that the sanctions list and making sure they're not dealing with sanctioned entities or individuals.
Thanks. I don't know if you wanted to add anything to that, and then I'll
sorry, Senator. Just add to Dr. Zernzak's comments. Shortly after the Russian invasion of Ukraine, we actually requested some information from the government through a FOI request as to the total amount of assets seized, frozen, and even number of persons and entities sanctioned. However, DFAT actually refused that request, which was surprising, despite our best efforts. So I think that's just an example of where greater transparency and sort of reporting helps build trust and actually can inform the Australian community about the effectiveness of Australia's sanctions regime, including asset freezing as well.
Thank you.
Thank you very much, Senator Ciccone, and thank you to our witnesses for appearing this afternoon. The committee has set Monday the 2nd of December 2024 as the due date for responses to questions taken on notice. A big thank you to all of our witnesses who appeared for the hearing today, as well as to Hansard and Broadcasting for their assistance. This concludes today's hearing and the committee stands adjourned. Thank you very much, everyone.
Thank you.
Thank you.